Please, Your Lordship.
Yes.
We were here in connection with an appeal which was supposed to be listed today. But for some reason, my Lord, the bench is not available and therefore, possibly therefore, it has not been listed today.
Yes.
May I just make a submission that if it can be taken up tomorrow?
Which matter?
Tomorrow the bench is available otherwise. DB3.
Which one? Division 3.
Yes.
Is it an appeal against my order? They'll list it, I think, accordingly. It'll be taken up tomorrow. We don't need to pass the orders. I cannot pass orders, yes. Yes. You make a request to Registrar General.
Okay.
Item number 1.
Yes. Yes, Mr. Panti.
Please, Lordship. Lordship, with this affidavit which has been filed by the NHAI, I've gone through it. Works, my lord, they're carrying out, but my lord, not in full swing. It's slow pace, my lord. And the affidavit which they filed, if my lord kindly come to the first page first. Page number 1.
You wanted to file a response or you being oral response?
I'm just only submitting, my lord.
You won't file a response.
Response, my lord, for filing the response, my lord, I have to go and inspect the road personally, then that will be proper, my lord.
Yes.
I inquired from my colleagues out there, and they're saying that, my lord, there are patches which are, my lord, in the worst condition.
No, but one thing is any repair work or renovation work or, is it being carried out or not?
They're carrying out. No doubt, they're carrying out.
They're carrying out. That's simple.
But there are patches, my lord, which are in more.
You can't expect it to be like super highway in such a short time, but it's not that they're leaving it, neglecting it.
No,
They're looking after it.
we are doing it, man. We are continuously
They're
trying our level
looking
best
after.
to.
How many machines you put there?
My lord, I don't have the.
How much
data
bitumen
on
have
that.
you used in the last 1 week?
2 contractors have been given for 52 kilometers each, my lord, and both of them have.
52 kilometers each.
Yes, my lord.
What is the kind of manpower to deploy?
My lord.
What kind of manpower and machinery to deploy to do 52 kilometers?
My lord, 1 year time is given as per the contract, but we are trying to impress upon them that.
So that is what I'm saying. How much manpower and materials,
My lord,
machines will you deploy?
all those details I am yet to obtain, my lord. The only thing I have been furnished it with some status reports and what patches
Right.
they have continued and wall.
See, it should not
protection
just
wall.
be any cosmetic kind of, of construction. It's cosmetic, right?
No, my lord.
So it should be like from not only cosmetic things are being done,
It's a,
just to avoid the
for a
scrutiny of the court.
strengthening of the road is
That is what is happening, my lord.
which was pending, my lord, which we are now have initiated, and we expect by next March, my lord, we believe that it should be anyhow.
You do one thing, Mr. Panthi.
My lord.
We'll do one thing. We'll post this matter after after 4 weeks or 6 weeks,
My lord.
and that time there should be some substantial improvements.
My lord.
Okay, we'll record that.
My lord, if I may pray, my lord, if a joint inspection, my lord, with the respondent and the petitioner, my lord, the amicus, if my lord may permit, that will be proper, my lord. So that
Petitioner and the amicus.
my lord,
Petitioner is
I'll personally visit, my lord. I'll personally.
No, that will be. Let them do what they have to
Yes,
do.
my lord, we'll provide them
Yes,
for
sir.
a visit, my lord.
To the affidavit filed by the
Because in the affidavit they filed,
National Highway Authority of India.
the report says, my lord, 22/7/2/99/24, and photographs which has been annexed.
They're old photographs.
There are, my lord, two, 3 old photographs, my lord.
No, doesn't matter. Yes, we will.
In fact, that is landslide clearance photographs also, my lord, also has been annexed.
Yes, Pavna, to the. India dated 11/9/2024, putting on record a status report. Status report with regard to the ongoing construction of sections of NH6, that is Jowai Ratachara Road, which is about 102.255 km in length, which is being constructed by two contractors, namely A. Messrs. Purvanchal Bill Tech, PURVNCHL Purvanchal, then Bill Tech Private Limited, and B. Messrs. Dhar Construction Company, comma, Mr. Panthinan Amicus submits that though works are going on, no noticeable change has been witnessed. He praised that. Next paragraph. Ms. S. N. Gupta learned I'm an advocate. What is
No, my
designation?
lord, advocate for National Highway.
Oh, yes. Ms. S. N. Gupta learned counsel for the NHAI has submitted that work is going on a war footing, and that work on a war footing to repair and construct the said high portion of the highway. In view of submissions and in consideration of the fact that the status report shows that certain work is going on, poses matter after 6 weeks for further orders and for response by the learned amicus if necessary.
My lord. If my lord
Also, who's been
make
given
the
liberty,
observations.
who's given liberty to to conduct his own inspection.
My lord.
So if before 6 weeks, if you can come up with some, because you've seen what it is now, and in 6 weeks time, if you can go, everything. Anyway, we'll have to arrange something also.
Item number 2.
With regard to, but it'll be come up to 6 weeks. We'll give you
Obligations.
government support also. Yes.
Lordship, item 2, we have filed the affidavit, Lordship.
When have we filed it?
Yeah, Lordship, we filed last Friday. We have filed last Friday, Lordship. Lordship, just take your Lordship to page 17.
It's 17.
Lordship. 24th June 2024.
Yes. What is the length?
So, Lordship,
One crore would be 1 kilometer only.
Lordship, no, and then I take,
4.5.
Lordship, I then take to page 18 also.
Yeah.
Of course, it's a previous date, 19 June.
Yeah.
It's more than 2 crore some amount. Lordship, my summation at this stage is this: so far the implementation of
Have you work been awarded or it's just been
Lordship,
still
this
in
is in the final stage of
still in the desk?
Lordship, is still in the final stage. We haven't received. So once this is sanctioned and the final stage is raised, Lordship, then the execution will start.
Where the money come from? Capital outlay for bridges, sales schemes. Yes.
My lord, here, these letters, my lord, they keep on issuing. And my lord, when the work will commence, at least they should assure. And in the meantime, my lord, temporarily, at least, my lord, those potholes which are not, the potholes which are, my lord, lying unattended, at least they should, my lord, make the road motorable, my lord. Those patches, at least, my lord, temporarily, as a temporary measure, they should fill up the potholes, my lord. That is my humble prayer, my lord. Till the time this finalizes, this, my lord, tender is
Where
finalized.
is it that where the photograph 17 to 27? This is which stretch? The entire stretch like this.
They have carried out, my lord, in between they had carried out. Here what had happened, my lord, they are done with the sand and the, my lord, the small pebbles and not blacktopped. Again, my lord, 2-3 days plying the vehicle, my lord, it's coming out.
Mr. Khan, what's the exact length of this road? That in question.
74 kilometers, Lordship. 74 kilometers.
No, for sanction been given?
Will it to Balar, my lord?
Lordship, I said it's still in a different phase, Lordship. We have yet to get the sanction.
No sanction has been given. It is only a request for a
So for the patches that he is cursing, stating Lordship, Lordship can issue some direction like, in the meantime.
No, that's your affidavit. It's not a sanction.
No, not yet.
It's not a sanction. It's just
No, not your sanction, Lordship.
then request has been made.
That's the proposal.
Lordship, yes. It's still in the process of finalization. So.
And will it meet the, the requirement of, if he says how much, what is the entire length of the road?
74 kilometers.
74, my lord.
The entire stretch is in bad condition.
Lordship.
Yes, my lord.
There are patches
Mostly,
which is bad mostly.
mostly, my lord.
So for some urgent patches, it has to be addressed to Lordship. Lordship can pass some in direction in the interim.
That's 8.5 to 4. That's why I'm asking.
And Lordship, if I take Lordship to page 4, just for a moment, page 4,
Of the affidavit.
Lordship is status report of Maflang Ballard Road. If you come under the section from Maflang to Wailoi, Lordship, and below that, section from Wailoi to Ballard. Under B1, and if you come to the third paragraph of B1, Lordship, third paragraph, relevant part, it may also be mentioned that the above proposal on being dropped by MDNR, the state government is contemplating to take up the same project to World Bank.
Where are you reading?
So, Lordship, page 4, section third paragraph, Lordship, B subclause 1, and the third paragraph of 1.
That paragraph. Imagine as well being dropped by. Proposed, that means that.
My lord, kindly come to a paragraph prior to this. It says how the proposal has not been accepted. They have given the proposal to the donor ministry.
No, that's dropped, the recording here is dropped by donor.
My lord.
So that means this is a stalemate situation.
Still, my lord.
And this status report is dated?
This report is dated to Lordship
Dated?
17.
Where do you
17
get the
September.
date from?
17, Lordship, page 2, the last paragraph.
Very sad situation. Stop. And
Yes.
affidavit.
In fact, my lord, there is no date.
There have to be a status.
There is no date. Status report, there is no date, my lord.
No, the affidavit we have filed on 17 September. Lord.
So we take the status to be as on
That was on 17 September.
17 September.
Lordship. There's an ongoing process, Your Lordship, and before the next date, we will file some more.
But why you made proposals only for this 13 kilometers?
No, Lordship, Lordship will take to, if I take Your Lordship to page 10, the detailed discussion is at page 10, Your Lordship. And donor.
Yeah.
Decision of competent authority come minutes of the third import inter-ministerial committee meeting held on March 27 under the chairmanship of so-and-so. The entire detailed thing, Lordship.
So that where's the section?
Serial number 12, Your Lordship. That will come at page
Yeah, it's proposal, Lord.
12.
This is from Donor Ministry,
Lordship is.
which been rejected.
Lordship is.
And this is of March 23, my lord.
Lordship will just come to page 12, clause to 12, and under the heading 12, Your Lordship, why it was rejected in the right side. May not be selected as major road portion is already in a reasonable good condition.
What about this 28 February letter 2024, NHAI page 6?
Annexure 8,
NHAI, your affidavit,
Lordship,
page 6.
page 6.
It's given NHAI to the
Lordship, yes.
status report. What is this?
This is also letter from the Under Secretary, Your Lordship, to the
So what does it say? You read the subject.
subject is, Your Lordship, revised administrative approval and sanction for improvement and rehabilitation of pavement, including widening to the intermediate lane of Maflang Cart Road from chain number so and so and so, and Moplang Ballard Road from chain number so and so. And Lordship, the amount sanctioned here is 44 crore.
No. What's the letter about?
This is the Lordship. It's collateral with
No, but is this amount already been placed and any?
No, nothing. As a summary, Lordship.
24, 20 February. What's happened in pursuant to this letter?
Lordship, we need to get a specific instruction on
How
that.
an extent affidavit without having proper instructions?
These are all, Your Lordship, the instruction that we receive, these are all in the stage of interdepartmental stage and yet to reach the final stage.
How have you referred to this NHAI in your affidavit? Let's see. Where you mentioned it?
Page.
This one, page 6,
Page
where you
4.
mentioned it in the affidavit?
It's not there.
What? Paragraph 2, that's it.
It's not there, my lord.
No, Your Lordship, we have annexed the status because we have to go, Your Lordship,
You have to explain the status, correct?
but Lordship, now we come to page 4, Your Lordship. Page 4.
You know, see, Mr. Khan,
No, Lordship,
like, with due respect, we just got to run around the bush.
No, Lordship, only thing is this, the details in the status report is given, Your Lordship. We thought
Kindly
it.
file a detailed affidavit. But by 1 week, yes, sir. An affidavit to bring on record the thesis report with regard to construction of Moplang Ballard Road, pursuant to order dated 11/9/2024, have been filed at point number 3. Certain letters and certain letters and approvals have been annexed to the affidavit, which is stated to be part of this report. But however, there is no detailed explanation as to their relevance or the situation. Stop. Though attention has been of the court been drawn to 2 letters dated 24 June 2024 and 19 June 2024, it is noted that the same is only a request and not a sanction or approval. And that too is with regard to only 13 kilometers of the stretch in total. Stop. State response to file detailed affidavit in this regard within 10 days. This thereafter. You may have to explain the.
Lordship, 2 weeks, kindly grant us 2 weeks, please.
I'm going to list separately.
Item number 3.
The Khan is that affidavit. At least explain. We expect the court to go into a.
Apologize. We have just annexed the status quo because
No, that's not the
too
way.
detailed.
This report should explain.
And there is nothing conclusive.
At least you put it down so it's easy for the digester, so not to play cat and mouse. Yes.
Apologize.
May it please your lordship. Lordship, in this matter, the state is supposed to file their affidavit.
Where's the state?
But we have to file the affidavit, my lord. We pray for 3 weeks' time, my lord. We are
Ready?
preparing the affidavit, my lord.
When?
My lord, we need 3 weeks' time, my lord.
Why so much time? 3 weeks time. This gun that
GST matter, my lord.
GST, yes. Yes, as prayed further 3 weeks time granted to the respond to file affidavit. This thereafter.
Obliged.
Item number 4.
My lord, I appear for the petitioner in the instant case.
Yes, what's the matter about?
Required to file an affidavit.
My lord, this is a matter. No, my lord,
Ma'am,
3 weeks' time
I
was
require some
granted
more
last time. No, my lord, this matter may be heard in some urgency because the limitation period for filing the appeal will end soon. It will end in 6 days exactly. The lordship may kindly see, my lord, I have a very short case that the impugned order, A17 impugned order, is in gross violation of the A16 Master Circular. If I may take your lordship to page 117 of the writ petition, madam. Page 117. Page 117, the 4th line from the bottom, my lord. it reads, in fact, a separate letter for each hearing / extension should be issued at sufficient interval. In the instant case, what happened was that, my lord, 3 hearing notices are mandated by the A16. 3 hearing notices are mandated. My lord, am I audible?
What's the matter about? Can you kindly, we are not, see, what is the matter about which has so much urgency? What are you
It's a
agreed
customs
with?
matter, my lord. It's a custom.
Yes.
I'm aggrieved by the A16. I'm agreed by the A17 impugned order, my lord, which was issued. The hearing notices, as per the master circular in A16, says that 3 notices are to be issued with sufficient interval. In fact,
That
in
master
the instant
circular
case,
dated
the last 2 notices,
Yes.
17, yes, master circular issued by the Ministry of Finance says 3 notices. The last 2 notices in the instant case were issued on the same day, my lord. On the same day. This is in gross violation. And if I may, I substantiate my case by, if I may take your lordship to page numbers 95, 98, 101 and 104.
Yes, Dr.
These are the
Mosika.
postal receipts.
Why you not file your affidavit? Only on that point that, this violation of circular,
Only
from
on that
17
point.
circular. That's the only
on
point in
that
the entire case.
Yes.
It appears that's the only point.
That's
That's the only point.
Was no issued.
They also have appellate remedy, madam. There is
Yes,
order passed by the commissioner, additional commissioner.
See, this is a...
One second, Mr. Musa.
My lord,
1 second, please.
yes.
Yes.
Well, I'm praying for only 1 week, madam. I'll file an affidavit. The matter may be heard.
Let him file after 1 week, yes.
No,
We have to have it record.
no, my lord, let there not be any coercive action based on the impugned order, my lord. Let that-
Regarding your appeal, also will give you some question later on. Yes, Dr. N. Mosika.
No, my lord,
based on-
it will be noted, my lord.
Yes. We'll note it, yes. How much time?
No coercive actions, my lord.
A week's time.
No coercive actions.
Dr. N. Mosika prays for a lot of further 1 week's time to obtain instruction to file affidavit. They expected that then within 1 week the said instruction affidavit should be
No
on.
coercive actions.
Yes. Till
There is no question of any coercive action, madam. The goal is
No, my lord, they can see the actuality.
against the petitioners. Yes.
No coercive actions. Yes, my lord.
Hearing.
Yes. It's recorded.
Item number 5.
Next week, my lord. Next week.
Yes. Next week.
Okay. Obliged, my lord.
Meghalaya Cess Act is under challenge, and 1988, my lord, that the writ has been filed challenging Meghalaya Cess Act and the power of the state government to impose tax on minerals.
When was it filed? The first.
It was filed in 2019, my lord. It was awaiting the outcome of 9 judges bench judgment in MA. And 9 judges bench judgment I have placed on record holds that the state has power to impose tax, my lord.
If I may
Yes,
pray, my lord,
Mr.
if my lord, before my learned senior starts, if I may pray, my lord, this matter may come up next week, my lord. Next week, my lord.
You know something? The archival journals become very rare species last year. I hope they will become endangered after some time.
Large
Honestly, my lord. On his behalf.
Your lordship kindly see, now this issue is no longer racing degram. My friend has been dragging for last 3-4 hearing.
Yes. You is it your submission that now the judgment of the Supreme Court covers this
Yes,
case
kindly see 2 pages
without
only.
substance?
Everything, prayer, kindly see prayer, my lord. Kindly see prayer. Prayer is at pace.
This is Changresu appearing here
My lord.
for the petitioner.
Yeah, business.
Yes.
My lords, kindly accommodate us today and have it next week, my lords, any date convenient.
Your lordship kindly see the prayer, my lord. For the convenience of my friend, my lord. And only 1 paragraph of the voluminous judgment. Conclusion only. Prayer is to withdraw, recall, or otherwise forbear from giving effect to Meghalaya Mineral Cess Act 1988. after adjudging the same ultra vires of the Constitution of India. So this is the, and then your lordship will see the judgment, paragraph 342, last page of the judgment, 342. At page, my lord, you'll find page 134 of the judgment. Page 134, my lord, and paragraph 342, my lord.
Conclusion.
Yes, conclusion, my lord. Yes. Your lordship may skip that part, is not relevant. Entry B. Entry 50 of list 2 does not constitute an exception to the position of law laid down in MPVR Sundar Mayer. The legislative power to tax mineral rights rests with the state legislature. Parliament does not have legislative competence to tax mineral right under entry 50 list 1. It is being a general entry, since the power to tax mineral rights is enumerated in entry 50 list 2, Parliament cannot use its residuary power with respect to the subject matter. Entry 50 of list 2 envisages Parliament can impose any limitation on the legislative field created by that entry under a law relating to mineral development. MMDR Act as it stands has not imposed any limitation as envisaged in entry 50 list 2, my lord. So B clearly says, my lord, that we have the power to do that's the only short issue, my lord.
Yes, on the request of Mr. T. Paul, Assistant Counsel for the petitioner, this is matter for 1 week.
I'm highly obliged.
Any mention?
Please, my lord. My lord, I beg to mention item 20 and 21, my lord. On behalf of
My lord, joint request, my lord. I'm being led by Additional Advocate General in this matter, these two matter.
What matter? Service matter?
No, my lord, is pending due.
Non-payment of outstanding bills, my lord.
How long?
About 2 weeks.
2 weeks, my lord.
2 weeks.
If you oblige me.
My lord, may I? Item number 29, my lord.
$29?
My lord, 29.
$29?
My lord, 29.
Andreas Council?
My lord. My lord, Mr. Shulai is leading this matter.
Okay. 2 weeks. Yes.
Please, Your Lordship, my lord, item number 19, man. This matter may be taken up after 2 weeks. This matter pertains to that house constructed near the river Mentu.
Yes, why don't you do it?
If
It escapes the
yes, I have gone through the order which Your Lordship has passed. It seems like not affect this writ
It
petition.
not affects construction. Or will it be affected?
No, my lord, I have gone through, but
Who's preparing for? Yes.
Lordship, this on PIL Lordship, so far as the Mintu River is concerned, it's pending.
This is totally different from the Mintu River.
Lordship,
That's regarding dumping of spoils in the river.
Lordship.
It's nothing to do with the construction near the river.
then we can have
We
it
can have
on
after 1 week. Lordship.
2 weeks, my lord.
Okay, 2 weeks. Yes. I request the petitioner. Yes.
Obliged.
May I please, Lordship? I beg to mention item number 25. Item number 25, Lordship.
$25?
Lordship, no objections, Lordship.
Where's Mr. Sheikh?
He is out of station, Lordship.
No urgency.
No urgency.
3 weeks. Yes.
Lordship, this was part no, earlier to you, Lordship.
Part matter.
Yes,
This Johnny Marbo.
yes, Lordship.
3 weeks. Not urgent. It's not urgent for them.
Lordship,
Yes.
I love Lordship.
Lordship, similar fare for item number 26.
No urgency.
No urgency, Lordship.
3 weeks. Yes. Other side, you're there.
I have informed Lordship.
You are mentioning over.
No problem.
My lord, item number, whether, my right friend is mentioning item number 2 or
No. Yes. Yes.
onward. Sorry.
Lordship,
Lordship,
I'd like to request adjournment for item number 28.
Alban Frederick's aim.
Yes, I want to be there physically, Your Lordship.
28, you're there. What's the matter about?
This is, we are challenging the order of the tribunal, my lord, in which our condemnation petition has been dismissed.
Which aimship is this?
This is Million, my lord.
Challenging what? Election of whom?
Election of this presence aim. And there was some delay, that's why our condemnation delay was rejected, my lord.
How many days?
Around 40 plus days, 46 days. Contention of the one-man
How many
tribunal.
days?
Contention of the one-man tribunal is that I don't have the power to condone the delay.
No, how many days was the delay?
Around 46 days.
46 days.
Yes, my lord.
No, get some.
I just want 2 weeks' time, Your Lordship.
2 weeks.
Obliged.
Please, Your Lordship, I beg to mention item 27, Your Lordship.
No.
Your Lordship, I need some more time to do research, Your Lordship. I couldn't.
You done research.
Your Lordship,
Research goes against you.
Your Lordship, I'm humbly praying Your Lordship time, Your Lordship.
Because there's nothing else. Because may means up to 50% of sentence. Not may that you can give 1 day.
Your Lordship, I've gone through the judgments given by my learned senior. As such, Your Lordship, I'm praying.
There's one judgment was a per and curiam judgment.
So, Your Lordship,
That helps your case was a per and curiam judgment.
Your Lordship, I'm praying for 2 weeks' time, Your Lordship.
2 weeks time. Okay.
For research, I think
For research.
1 day is enough.
Your Lordship,
Just perform last rites. It's 2 weeks. Okay.
oblige, Your Lordship.
Yes.
Please, Lordship. Lordship, beg to mention item number 30. Conducting counsel is unavailable, Lordship, today. If you kindly have it next week, Lordship.
13 on whose behalf are you mentioning?
Petitioner, Lordship.
Mr. Sheikh,
Mr. A. Rashid, no, Lordship. Mr. A. Rashid.
Mr.
A. Rashid. He's from Guwahati, Lordship.
But his name is not here. Number 10, Deepika Hajong. Deepika Hajong.
No, Lordship. A. Rashid.
No. The case, the name of the petitioner.
Dr. Subhash Chandra, Lordship. Item number 30, Lordship.
30.
Yes, Lordship. 30.
Oh, see, I thought 13. Yes, what's the other side?
No objection, Your Lordship.
3 weeks. Yes.
Oblige.
Or 4 weeks because go after puja. Yes. Yes.
Please, my lord, I beg to mention item number 24, my lord. I pray for 2 weeks' time.
On whose behalf?
Easy moment, my lord.
Any urgency?
No urgency, my lord.
Okay, 3 weeks. Yes. We'll give you long dates, give you time to prepare. Yes. Yes.
Oblige me.
Follow.
Item number 1.
May it please, Lordship. Lordship, in this case, I've challenged the inclusion of the...
No, see the last order.
Yes, my lord. So basically, we had a meeting with the respondent village, my lord, and we have decided that some more time is needed for settlement. So we have written a letter to district council, joint letter from the petitioner as well as the respondent, requesting the district council to keep the notification in abeyance, my lord. So the matter is now...
Where's the council? Is that correct, Dr. Mojika? Let's see. Have you received the letter?
Yes. The officials have received, my lord.
They want us to keep in abeyance in order so that they'll try to.
Now, the parties, that is the petitioner and the respondent number 6 here, number 6.
Yes, my lord. Respondent 6.
Have produced a letter addressed to respondent 125 seeking the withdrawal of the impute notification in question. Stop. Next by Dr. M. Mozika, Janet, Constitutional Council on behalf of the respondent notified to obtain instruction set letter, which is dated. What was the date?
Date they have not mentioned in the office copy, my lord.
August 20.
Yeah, the date, the letter. Dates of the 3 weeks, yes. Take this back.
Bless you, Lord.
Much obliged.
Item number 2.
May it please, Lordship. Lordship, we have received the affidavit filed by
Which
the
one is it?
respondent.
Wait, the file can come out. We'll have those matters all after tomorrow. Is tomorrow is. Yes, sir. 25th. Yes.
Lordship, respondent number 1 to 6 have filed their counter affidavit, and respondent 19 has filed also.
16 to 19?
No, 19, Lordship. 16 did not file. Respondent 19 filed.
Rely on the same affidavit, Lordship.
10, 12, and 13?
And if for 10, 12, 13, Lordship.
You filed?
No, Lordship, they haven't filed.
Lordship, I will rely on affidavit filed by state.
They are relying on the affidavit filed by the state, my lord.
What's it for today?
Issue is now this writ has become infructuous in the sense, my lord, that they are challenging the interview for appointment. Interview has already been held, appointment has already been made, so they have to file a fresh petition challenging their appointment, my lord. That
We have filed on the basis of that.
and they have been
recent
seeking
Supreme
time to
Court
file a
judgment,
joinder.
Lordship. Lordship, the basis of this writ petition, Lordship, was on that recent Supreme Court.
What does it say? Does it say your case has it become infructuous?
Lordship,
on
we
examination?
yet to receive instruction on that one, Lordship. Therefore, I'm praying for
When
some
does
time
it
to
file the
file.
affidavit?
Long
Just
time
in the
back, my
last
lord, this
petition,
affidavit was filed precisely on, my lord. Your lordship will find that
13th
affidavit.
of September.
Yes, my lord.
8 May. The 8th of May.
Therefore, Lordship, I'm praying for 2 weeks' time to receive instruction, Lordship.
Yes, Mr. Number 19. Last and government affidavit was filed when?
8th May, my lord. 8th May.
Didn't we?
May, June, July, August.
Also, but the
September,
entire
October.
affidavit we just received yesterday, or I mean, in the last occasion, we received from respondent 19 also.
Yes, prays for 1 week's accommodation to enable
2 weeks, Lordship.
2 weeks accommodation to enable the obtain instructions on the affidavit filed by the writ petitioner stop by the respondent, the state respondent and respondents number 16 to 19. Next paragraph, the letter Advocate General submitted that the matter has since been rendered infructuous. However, in interest of justice, this affidavit is
Deeply obliged.
Item number 4.
My lord, by way of this miscellaneous application, I am seeking for condemnation of 799 days, my lord, in filing an appeal or review petition, my lord, against the judgment or the date.
who appeared for the petitioner
Your
in the
Lordship,
earlier
notice is not yet issued.
Notice.
who in the main writ petition.
Main,
It's Mr. Maolong's office appeared, my lord. We have actually informed them to come.
You heard Mr. P. Ubin, it's miskit number 10. And so issue notice to the respondents as to why the delay of 749 days, 799 days, be not condoned. This steps were taken by this AD within 3 days, just after 3 weeks.
3 weeks.
Lordship.
Obliged.
Item number 5.
Lordship, in the contempt matter, we have filed one.
You wanted this on Wednesday?
Lordship,
You wanted this on Wednesday? You made a prayer last.
last date, your Lordship, order was passed on 19/9/2024.
Yes. Mr. Jha,
My lord,
the very serious.
my lord, the miscase has been filed by them, my lord.
No. See, one thing, Mr. Jha,
My lord,
one respect to the fact to file a miscase. Now, certain things have happened
my lord,
between the order being passed by the single judge and the matter appearing in the appeal.
my lord,
And you file a contempt application totally concealing everything.
my lord, had it been, my lord, the stay of the order passed by.
I will allow you to withdraw it. Otherwise, contempt between the court and the contemptor, and we don't want to inflict cost because they are daily wage laborers. That's the only consideration. Yes, The perusal of contempt application shows that the order alleged they have been violated has since been taken on appeal, whereby interim orders are operating, where interim order dated 17/5/2024 are in operation stop. It is noted that the interim order by the division bench had been passed prior to institution of the contempt application. Accordingly, there being no merit in the contempt, it seems this case was disposed of. We're just letting you go. Otherwise, if they're not daily wage laborers, we would have.
Lordship, a word of caution is needed to the petitioner if your Lordship pleases, because this.
It's okay, let them be. They don't understand the illiterate.
Item number 6.
Supposed to file rejoinder affidavit in this matter.
Where the
Please,
petitioner?
Lordship, I'm praying for
You're not filing.
the two. No, Lordship, we'll file in 2 weeks.
How many times you ask?
This is our third time, Your Lordship.
Third time.
Lordship, it's the 4th time, Lordship.
Is the fourth time? No. Rejoinder
Lordship, just
closed
2 weeks
on behalf of respondent number on Mr.
Digatta. He's not well, Your Lordship. This is our last
Fourth
time.
time, rejoinder is not by right. So, list the matter for hearing. It's otherwise the things are complete. The petitioner maybe it's allowed to file rejoinder.
Hello, Your Lordship.
Yes.
Obliged,
But
Lordship.
for hearing before the hearing date, yes.
Item 7.
Please, Lordship, the private respondent, short private respondent has filed the affidavit. But it stated that on the last option, they said that. Yes, Lordship. For Villa.
They have filed it. Where's
Respondent number 1 has filed, Lordship.
Objection.
The respondent number 2 and 6, they said that the earlier occasion, they said they will be filing the affidavit.
Objection.
Status for filing, Lordship.
Who is respondent number 1?
Respondent number is the private respondent.
We have filed the response. Yes. What do you object? What's the objection?
Well, the delay is 751 days.
How many days?
751 days. But the plea taken by my friend is a delay of 518 days. So application is suffer from that also. And there is no explanation.
Not rightly computed also.
But if he wants, he can withdraw and file a fresh calculation.
Lordship, in my para 24, 22 and 23, I have explained it. Maybe there is a miscalculation, but however, there is delay is not intentional. I have explained it is actually, Lordship, this is just my lord. What happened is this: due to some difficulty, the petitioner was not able to approach before the court and filed this restoration petition, and that has been explained. I have explained in detail. Of course, there is a technical, maybe according to my calculation, there is only 700 that day was there, but 491 days.
491 days.
Because that was that some delay was experienced due to the in view of the judgment of the Supreme Court, Lordship, where it is stated. As I will also enclose it in that lecture.
See, one thing, it was dismissed for default on 1/2/2021, correct?
Yes, Lordship.
Yes. Then, now you said that para 3, however, due to the onset of COVID-19 pandemic and ill health procedure, the said matter was dismissed for default. Okay. That, where's your other explanation? You're not interested only then. After dismissal, then he went, gone to the council, then after opening copies, as per customary law, he went and had a meeting again. What is customary law? Does Garu customary law operate also? Suppose case gets dismissed for default, as per Garu customary law, you have to go back to your client.
No, the intention of the
No, number 11, what have you said there?
Yes,
That after obtaining of copies, as per Garu customary law, you're writing new law now for Garu customary law.
No, Your Lordship.
Considering a dispute involved worship.
Your Lordship, to that effect, may I answer Your Lordship?
No need to answer. Your power is very clear.
Because I have enclosed even the meeting is where they have. That is I left it to the petitioner because the petitioner, she said that after obtaining because this
Where is the medical certificate?
Of course there is no medical certificate, Your Lordship. Because they said that she was treated by the local medicine practitioners.
Huh?
Local people who like that copyright they call the local practitioners, medicine practitioners. That's why I have said it.
Now you say you obtain the copies, then you go to para 17 in 16.
I will receive the relevant document.
You come to annexure 2, okay? Because I think it's like contradictory. This your annexure 2. Okay, this is the. See, this is on 3rd of May 2022. That the meeting insisted on being informed dismissal of case pending for novel High Court law. Okay. It be responding in 3rd February of 1 year since dismissal. Fine. Then you come to para 16. That thereafter the application on the council and some relevant documents will copy representation were not handed over and since misplaced by applicants due to bona fide mistake. Now you misplace you through the petition also.
Yes.
Now is this even you might sometimes we take the plea of we are poor tribals, we're illiterate. That excuse sometimes, like in this case, will not hold good. You misplaced it. You had the meeting since May 2022. Then May 2022, April 23, you threw away your file. Then you applied again in July 23. Then you received it in you drew the miss case, you file a fresh. What can you do, Mr. Sangma?
Lordship, my only humble submission is because there's a merit in the case, Your Lordship. Of course, there may be some technical issue regarding this, and that number one, the petitioner has not at all have any intentionally to delay in filing the petition. That's number one. Actually,
now look at it. Look after para 24. Look at 24(1) of para. Read from dismissal. Read.
Yes, para 4. I have
24. Yes.
Yes, I have.
Now you say in your main application you said how many days the delay? 491 at para 1.
Yes.
And now you read your sub para 1 of 24.
Para 1 is. This is because the Lordship may just read it para 24 sub para 1 from the dismissal of the petition 103 of 2017 till the filing of MC WPC number 181 the 20 of 2020. There was a delay of 898 days. That is the repetition number, that is with effect from repetition number.
So if from dismissal in 21, you said 898 days when you filed the first miss case was withdrawn.
Yes.
So 898 days that time, and now you withdrew that was never condoned. Now again how do you come to 491 days? Now para 1 you say 491 days. Now you see same date you say was dismissed 1 to 21, the delay is 898 days. How do you reconcile this? Of course, trying to understand also. What kind of formula are you applied? Mr. Chaudhary, you understand para 1 and 24(1? Does it make any sense?
But he is referring to the day when he filed the first miss case for restoration.
Doesn't matter. He comes with the same thing. The instant miss application being filed coordination of day 491 days as on 21/6/24 and preferring connected with application for restoration of prohibition which was dismissed for default on 1/2/21. Okay. Now come to 24/1. That from dismissal writ petition of 137 till the filing of, in this case, the early one, there was a delay of 898 days.
Yes.
So that time should have been less.
And because of this confusion, my lord, earlier also he withdrew. And the court gave a liberty.
Now
to file a
getting more
petition.
confused.
And the same.
Just do the maths and just come back. I'll give another chance. But we don't understand how you calculate the days. 491 days, and earlier you said 898 days.
And there was an exclusion, some exclusion was that the exclusion of day was the delay due to, in view of the
See, Ali should help the court to understand the matter. If you assess the court properly, if you have a good case, you'll get the order. But if you don't assess the court properly and you confuse the court, then the court gets confused.
Lordship, on the next day I will try to assist in the, but I'll just calculate it properly way, then I'll assist the court because.
And this is a matter after 2 weeks. The objection has been filed by the respondent one. This is a matter after 2 weeks. But it's very difficult to understand.
Item number 8.
Apply lordship.
Lordship.
Yes. Dr. Mozika, number 6.
But I'm appearing for Union, my lord. National Highway is the main respondent. Number 7. No one has appeared. If they can serve the National Highway.
Number 7? No.
Number 7.
There are 7 respondents.
Yes, Lordship. National Highway Authority of India.
No response were added.
Have you taken steps on them?
Lordship, I may be allowed to take fresh steps on
You're not taking steps on them? 7 and
Lordship.
6 and 7? No.
No, Lordship. 5 and 7, Lordship.
Yes, I'm appearing.
Yes, MS D. Mokta, learned counsel with such a praise funds allowed to take fresh steps on response number 5 and 7. Yes. By Rasid ED. Yes. List after 2 weeks.
Highly
For
overruled.
service report, yes.
Item number 9.
Okay.
May it please, Your Lordship. Lordship, I am required to file my rejoinder affidavit in the matter, Lordship. I pray that matter be posted for hearing, Lordship. I will file my rejoinder in the meantime, Lordship.
Yes, this matter for hearing. There is a permit to the join in the meantime. Yes.
Hello, Lordship.
Yes, answer.
10.
Lordship, we have received some instructions. I may be allowed to place it on affidavit, Lordship. From the instructions, what has come out is that the petitioner has resigned instead of taking VRS, which has been stated in the petition. In fact, she had resigned. And the second thing is, Lordship, the arrears and the leave salary, arrears of the salary has already been paid to her. I may be allowed to place it by way of
Lordship, let him put it in the affidavit.
She resigned or to VRS?
Not resigned.
So the only annexure appended to the writ petition says that she has been released from service. The instructions we have received is that she had resigned.
Mr. SDEP submits that instructions have been received. We praise that we have to place the same way affidavit. So submitted that contrary to the averments made in that petition, the petitioner not taken VRS, but in fact had resigned. Next one appeals now to obtain instructions also. Just after 2 weeks, yes.
11.
May it please your lordship. Your lordship, I'm praying for time in this matter to file an affidavit. We're awaiting clarifications, your lordship.
No objections, Madam.
Yes,
I
sir.
pray the interim order may continue.
Further 2 weeks, I must be allowed to affidavit. lists according interim order pass. Interim order, if any, shall continue next day.
12.
Deeply obliged, ma'am.
Lately to Lordship. Lordship, we've received instructions, my lord. So I pray that we may be allowed to file affidavit
What's the
accordingly.
instructions?
Lordship, the instructions we've received is that,
Some amount still pending. To be
Lordship,
paid to him.
however, the bills
Is
could
it
not be
admitted or not?
finalized due to the petitioner's failure to submit the required documents such as the test report, the invoice, etc. Lordship.
Yes, Mr. Samwa.
Yes, I'm not getting that. Here I have already submitted the completion report. I don't know what other documents they are requiring that to that effect.
How long for affidavit?
Lordship, since it's from Garo Hills, I pray for 2 weeks time.
2 weeks time. 2 weeks by the time. Now that senior GA submits that instructions have been received, she please was allowed to place the same by affidavit list for 2 weeks.
13.
Much obliged, Lordship.
Please, Your Lordship, this is regarding the pension matter.
Pension, yes.
On the last occasion, on the 14th September, both the parties were called. But the
They
petitioner
appeared for
does not
Lok Adalat.
No?
All the parties appeared for the Lok Adalat, National Lok Adalat. They appeared.
The petitioner did not appear.
Did not appear. Why?
I was not aware of it.
Not aware. Your counsel should have informed. Would have been saved the hassle. You'll file affidavit.
Maybe on the last occasion, it can be disposed, my lord. The pension, all the official letters will be sent.
Yes.
All the letters. I mean, all the orders for pension.
It's A movement 125. Submit the instructions have been received.
Well, not officially, my lord. They have informed you.
Yes, sir. Please that the matter will start 2 weeks, enable him to obtain instructions or to file affidavit. This accordingly is and so on.
14.
Yes.
Senior son VC.
Oh. Yes. It's a motion. Yes, Mr. Paul. Can't hear you.
There is some issue in the.
What's the matter about?
It's a tender. Tender matter, my lord. He is not the highest bidder, my lord. And
Tomorrow, let him come personally. Yes. Due to technical issue, this matter tomorrow. Yes. It's not been moved in the motion column.
Hearing. 15.
Hearing after lunch. We take the hearing after at 2. Yes. I'll see them. That Mazai matter can be taken up because Mr. Shulai is not here.
Shulai is not here. Yes.
Okay, I'm ready.
He isn't bereavement.
I'm just only the missed cases there 164, trying to allow to collect only 200.
But Mr. Shulai is
of course, he is in bereavement.
He is in bereavement.
Lordship, even Mr. Paul's connectivity is at time.
Is it done? Who manages your team?
Lordship, if it's fixed at 2.
No, it's the thing is that we can't take it up. When is Mr. Shulai joining?
He will
After
be
a week, Your Lordship.
week.
Then we'll take the motion after 1 week. Rest of the matters we'll take up after lunch. After lunch.
Item 15.
May I please, Lordships?
Yes. Where did we stop last time?
Lordships, the contention was raised by the respondents that I had not come before this Honorable Court with clean hands. If I may place my case in 5 minutes, Lordship.
But who asked for time to place materials? You or Mr. Sen?
Mr. Sen wanted
Compilation
to...
I have filed. I have filed a compilation.
If I can give a brief background, Lordship.
Yes.
Lordship.
You filed an affidavit of opposition?
Yes, there was no orders on the last. In fact, if I can just give a background, Lordship, this is a transfer petition seeking for transfer of the suit which was filed in a wrong court. But an injunction order was passed. Status quo was directed to be maintained by this Honorable Court. And thereafter, Lordship, my learned senior who is appearing for the contesting respondent, the committee which has been illegally formed as per the plaintiff, Lordship, they filed a they wanted to bring into record certain subsequent developments. So to say that some other suits have also been instituted by the present petitioner, and in view of those suits, possibly the present suit which is sought to be transferred perhaps has become infructuous. Lordship, on the last occasion it was heard, and I tried to appraise this Honorable Court, Lordship, that in fact suits were filed much subsequently on different causes of action which had arisen much subsequent to the filing of the present suit which is sought to be transferred. And as such, Lordship, the learned senior had submitted that he may be allowed to produce the certified copies of the other suits which have been withdrawn and is still pending to show that it's the same suit, Lordship. Lordship, if Lordship is pleased to take my transfer petition, page 13, Lordship.
Page
13. Lordship may come to page 11 first. Page 11 of my transfer petition. If I may read para 2, Lordship. Lordships have para 2 at page 11.
Page 11.
Lordship, paragraph 2.
It is to mention.
Lordship, page 11 of the transfer petition.
Yes, what is this?
Perhaps Lordship is referring to page 11 of the
order.
Page 11 of the transfer petition, paragraph 2.
One second.
Second paragraph of the transfer petition, Lordship.
Why the Lordship is holding this compilation?
Oh, that's filed today.
No, not last week.
For transfer petition with. Sorry. Page 11, right?
Page 11, Lordship, paragraph 2 of my transfer petition.
24 period 1.
Lordship.
Yes.
Lordship, that the petitioner begs to state that he is the duly appointed presbyter in charge of the Shillong Pastorate by order dated 4/12/2018, issued by the Bishop of the Diocese of Northeast India, Church of North India, as per the relevant provisions of the Constitution and in pursuance to the Diocesan Executive Committee meeting dated 30/11/2018. Further, he is the ex officio president of the Shillong Pastorate, All Saints Cathedral, Shillong. It is relevant to mention that the appointment of the plaintiff petitioner is not term-based like the members of the committee, but the same is permanent, until further notice by the competent authority, that is the diocese, and hence the term of the office of the petitioner plaintiff as presbyter in charge cannot be altered, modified, terminated, and or otherwise by any other body or authority, and especially not by the pastorate, Shillong Pastorate Committee itself, which is in fact presided by the petitioner plaintiff as its ex officio president. Thereafter, Lordship, may be pleased to come to para 6 at page 13.
Yes.
Lordship, being aggrieved by the acts and actions of the defendants respondents herein, on 22/11/2023, the plaintiff petitioner filed a title suit for declaration of right, title, and interest along with permanent injunction along with all other consequential reliefs inter alia for declaration of the impugned proceedings of the special general meeting dated so-and-so, special general meeting dated so-and-so, annual general meeting dated so-and-so, and all decisions, actions, etc. taken pursuant thereto as illegal, null, and void, and for declaring the impugned letters dated 20 so-and-so, dated so-and-so, and dated so-and-so, issued by the Secretary, Shillong Pastorate Committee as illegal, null, and void, along with the missed case for ad interim injunction under Order 39, Rule 1 and 2. Lordship, the suit which was filed on 22nd of November 2023 was challenging these, Lordship, 3 resolutions, 2 of special general meetings and 1 of an annual general meeting, and 3 letters, Lordship, dated June, July, and September respectively of 2023. Lordship, the learned trial court had taken cognizance of the matter and was pleased to pass an ad interim ex parte injunction order to a limited extent, Lordship, which your Lordships will kindly find at page 253 of the petition. Lordships have Annexure 3 at 253.
Yes.
Lordship, if I may read from paragraph 4, Lordship. The learned counsel for the petitioner has expressed anxiety that the 3 points mentioned in the letter will be put into effect shortly. These 3 points pertain to 1, endorsement of the AGM of the Special General Meeting resolution to not recognize the petitioner as the presbyter in charge of Shillong Pastorate and to discontinue the petitioner's ministry in the parsonage. 2, that the Shillong Pastorate will not contribute to the salary of the petitioner with effect from 1st October 23. And 3, that the petitioner is to vacate the Shillong Pastorate's parsonage within 2 months from 30th September. Without going into unnecessary details, some important facts may be noted. The petitioner is the presbyter in charge and is the ex officio president of the Shillong Pastorate Committee. The Shillong Pastorate Committee is a body subordinate to the diocese, which is in turn subordinate to the synod. From the materials on record, it appears that there is a dispute has erupted between some portions of the Shillong Pastorate Committee, the petitioner, and others at the diocese level. The petitioner, amongst other things, has argued that both the SGM and thereafter the AGM were not properly called, and the 3 points referred to in the impugned letter are beyond the scope of the powers of the opposite parties number 1 and 2, as per the Constitution of the Church of North India, referred to as the Constitution. At this early stage, only limited relief is granted on an ex parte basis, such that the petitioner is not deprived of his shelter and is not restrained from discharging his duties, which are continuous and continuing. Therefore, till the next date of hearing, the petitioner is not to be evicted from the premises occupied by him by opposite parties number 1 or 2 or any person acting through them or under them except by due process of law. And 2, opposite parties number 1 and 2 are restrained from interfering with the petitioner's discharge of his duties as presbyter in charge except in the manner as permitted in the Constitution. The third prayer regarding the salary, Lordship, has not been granted. Lordship, the order was passed on
24th
of November. Thereafter, Lordship, 4 miscellaneous applications were filed by the defendant 1 and 2, who are respondents 1 and 2 here. 4 miscellaneous applications were filed, Lordship. 2 under section 21, objecting to the jurisdiction of the learned trial court. Those 2 applications, Lordship, are numbered as Miss Case 127 and 129 respectively.
Yes.
I have enclosed them, Lordship, in my transfer petition. And at the same time, Lordship, the said defendants also filed 2 other applications under Order 39, Rule 4 for modification or vacation of the interim order. Lordship, the matter was fixed for hearing on 7th of December 2023. And on 7th of December 2023, Lordship, the present transfer petition was moved before this Honorable Court. And this Honorable Court was pleased to pass an order of 7/12/2023.
That we've seen.
Lordship. So status quo has been directed to be maintained till date, Lordship.
Okay, so as on today, now
Lordship.
yes.
Lordship, thereafter,
Was to take a territorial objection.
Lordship, yes, under section 21.
Fine.
Lordship, thereafter, Lordship, on 12th, now these are beyond the transfer, Lordship. These are, I'm talking about the subsequent suits which were filed. Lordship, on 12th March 2024, a suit was filed before the court of the Munsif. Before the Munsif, Lordship.
Okay.
Being titled suit number 1 of 2024. This was filed on 12th of March 2024. Lordship, the primary challenge in that suit was a draft election notice which was floated by the defendants, where, Lordship, the plaintiff's name was not included in that draft electoral roll and the notice. Lordship, subsequently, by way of another notice of the electoral roll, his name was in fact included.
Whose name?
The plaintiff's name, as a voter for the upcoming election. Lordship, and hence that suit was withdrawn. Thereafter, Lordship, on 8th of March, a fresh election notice came into play, wherein my name was there, and they had declared that the election will be held on 17th of March.
Yes.
As such, Lordship, on 13th of March, I have filed a second suit, again before the Court of the Munsif, challenging the notice calling for the election scheduled on 17th. Lordship, however, because of the pendency of the previous suit as well, whereby the draft election notice was under challenge, the electoral roll, both these matters, Lordship, were not pressed. Defendants were
2070, 2023.
2070 was always pending, Lordship.
Was always pending.
Always pending against the resolutions.
And then what happened to two missed cases, 127, 129?
They are also still pending.
This is pending adjudication. Dates were fixed, never taken up after that.
Never taken up after that.
Because you came to this court.
Lordship, yes.
When they filed a missed case of
7th
territorial
December, this 27T and its connected miscellaneous applications have not been taken.
Okay, fine. Now we are challenging what is the in this title suit of 27, you say that the prayers are different from the subsequent.
In title suit 27, my prayers are basically against 3 resolutions passed in annual general meeting and special general meeting, Lordship, as well as the 3 letters by which I have been communicated those resolutions. Title suit 1 of 24, which was filed and subsequently withdrawn, was in respect of a draft electoral notice where my name was not included.
That's filed in Court of Munsif.
Lordship. Thereafter, another suit was instituted, being titled suit 24, challenging the notice by which election was declared to be held on
pending.
Is withdrawn, Lordship, because the election was held and the matter became.
Okay, 2 suits filed withdrawn.
Filed and withdrawn.
Third, now what
Finally,
happened?
Lordship, the election was.
Why was this not brought to notice of the court when you heard it on the earlier occasion?
It was. That is what, because.
It was not.
Lordship, learned senior
Not
said
in, such, not in such clear terms. Before it was brought, it was just dabbling around. It was never clear, but what was the suits about?
Lordship, yes. So, because the suits were also not in front of us, so I can explain, Lordship. Thereafter, Lordship, on 17th of March 2024, a fresh pastorate committee with new members and new office bearers, some common and some different, was declared, Lordship. And against that election, or the fresh constitution of the pastorate committee for the period of 2024 till 2027, a title suit has been filed before the court of the Assistant District Judge, Lordship.
By whom?
By the plaintiff.
So you filed
27th
1,
May.
2, 3, the 4th suit you're filing.
This is the 4th suit, and this suit is still pending at the stage of
Right.
interim hearing on my Order 39 Rule 1 application. They have filed a caveat, they have filed their show cause, now it is fixed for hearing, Lordship. So, Lordship, my humble submission is that Title Suit 27, for which I have sought for transfer in this instant petition, was for the resolutions which were passed illegally by the committee of 2021 to 2024, by the previous committee, Lordship. Thereafter, the new suits which were filed, the first suit was for a draft election notice which became redundant, and the second suit which was also withdrawn was for for a stay of the election which was scheduled. That also became infructuous, Lordship, because it did not materialize. And finally, the suit which is pending now, where my learned seniors as well as other defendants, it's not the same defendants, other defendants have also entered appearance, and the matter is pending adjudication at the stage of Order 39. Now, coming back to the instant petition, Lordship, my humble submissions are, Lordship, that at the time of filing of this instant revision petition, I have not suppressed any of the material facts which had occasioned
At that point of time.
at that point of time, Lordship, and in view of all of those, the miss case which was filed under Order Section 21, as well as their applications under Order 39 Rule 4, as well as my pending Order 39 Rule 1 application, which is still, Lordship, pending for final adjudication, an order was passed by this Honorable Court taking cognizance of the matter to maintain a status quo, Lordship. And now, Lordship, another 9 months have since passed. Lordship, the position before the trial court remains the same. Subsequent developments may have happened, Lordship. And, Lordship, in my humble submission, Lordship, that this Honorable Court, with all due respect, my Lord, may not be the proper forum to go into the entire suits and find out, Lordship, whether it is infructuous or not infructuous or otherwise, Lordship. The learned trial court has the jurisdiction and is in a position to, Lordship, with all due respect, to give a finding on that. And they are well entitled to, Lordship, raise that objection in their Order 39 Rule 4 application.
Yes.
Lordship, my only humble submission is at this stage, if the suit is sought to be returned under Order 7 Rule 10, Lordship, no fruitful purpose will be served. Lordship, when the transfer petition is filed, sometimes, Lordship, as the saying goes, that a stitch in time saves 9. Lordship, in the interest of justice, considering that the Order 39 application is still pending, may be adjudicated by the trial court and decided within a period of 2 weeks or a month, Lordship.
Or after being transferred.
After being transferred, and Lordship, the matter may be decided on merit. Because, Lordship,
yes,
in view of in support of my contention, Lordship, on the previous occasion, my learned senior appearing for the diocese, Mr. Jindal, had supplied a Supreme Court judgment.
Where's the Jindal?
Your Lordship, I'm appearing on behalf of respondent.
We're ready with the matter.
Sorry, Lordship.
We're ready with the matter.
Your Lordship, the conducting counsel on the last occasion when the matter was taken up has already appraised this court. So,
about what?
Your Lordship, about the transfer application which is filed by the petitioner.
The transfer application before this court. Apprised this court about what?
On the last occasion, Mr. Jindal had placed judgment whereby the Honorable Supreme Court had essentially stated that the only consideration for a transfer petition is whether, Lordship, continuance of the proceedings before the trial court would ultimately defeat the ends of justice, and that should be the only
judgment was that?
Lordship, that was
2010 judgment, Your Lordship.
2010 8 SCC 401.
Para 12.
Yes, what judgment is that?
That judgment is 2010 8 SCC 401, Lordship. 2010 volume 8 SCC 401. Lordship, DAV Boys Senior Secondary School versus DAV College.
Right.
Lordship, para 12 of this judgment.
Yes, now we got it.
Lordship.
Para 12.
Para 12. In essence, Lordships, that if the court is satisfied that an order of transfer is expedient for the ends of justice, necessary direction may be issued for transfer of any suit, appeal, or other proceedings from a high court or other civil court in one state to another high court or other civil court in any other state. In order to maintain fair trial, this court can exercise this power and transfer the proceedings to an appropriate court.
Only one thing, the last suit still pending regarding, you said?
Last suit is for the new committee, Lordship. The new committee which has come on 17th of March 2024, and the manner in which the election was
yes, Mr. Sen.
conducted, Lordship.
Yes.
Does not prolong the matter?
Yes, my lord, will not prolong. My lord, before I get into my compilations, Your Lordship, one thing I'll make it. My learned friend has referred to paragraph 1 of his transfer petition, saying that presbytery in charge, his appointment for an indefinite term. Absolutely wrong, my lord. There is not a whisper in the Constitution. But as correctly pointed out by my learned friend, these High Court will not get into it. These are all to be decided by the trial court. But then what he said, my lord, is not correct. Number one. Number two, my lord, other confusion, my lord, before I answer all this thing, other confusion created the High Court's order. Now, my lord, my learned friend has pointed out, immediately we enter appearance, we file two applications. One, questioning the jurisdiction. Another, my lord, an application under Order 39 Rule 4 to discharge the injunction order because you have filed on a court without jurisdiction, my lord. And that against this, my lord, though this was fixed on 7th for show cause and hearing, my lord, without participating in the proceeding, my lord, he came here and filed this transfer petitions. Now, what order has been passed, my lord? Repeatedly they are saying injunction order. There was no such injunction order by this court. My lord, that was an order dated, my lord, 7th December 2023. The date it was fixed before the trial court also. Now, he sought for an injunction. Now, what is the finding of this court at paragraph 6?
712.
Yes, 712, my lord. The same day the proceeding was fixed there, my lord. On
First order.
Lordship will come to paragraph 6. Well,
yes,
I'll just read it. On consideration of the submission with the prayer of the London Council, inasmuch as the petitioner is directed to take step for issuance of notice upon the respondents. In the meantime, as praised for, status quo is hereby directed to be maintained as far as proceeding of the case between the parties before the trial court are concerned.
Right.
Proceeding has been halted. Even, my lord, I was waiting there, then the court was confused. Injunction was extended till 712. The court was, because of this order, could not extend it further.
And proceedings were held up.
Proceeding has been held up. And it's not proceeding now. So this is the thing. It's not an injunction. So injunction ended there. Now, my lord, I'll take your lordships to the compilation. Before the compilation, my lord, what was there appear in this instant suit? No, keep it. My lord, the instant suit is annexed with the transfer petition. At page...
Compilation.
Not compilation, your lordships. The present suit against which, my lord, this petition has been filed. This is annexed with the transfer petition at page 51. Prayer is at page
51.
Page 51.
51?
I would.
Circled 51, lordship. It's in handwritten 51 of the transfer petition. And internal page of the suit would be 26.
Yes.
I'll just read it, my lord. What is this, man? In view of the above stated facts and circumstances, it is hereby humbly prayed that your honor may be graciously pleased to pass a decree in favor of the plaintiff against the defendant. Number A, my lord, is important. For the declaration that the plaintiff is the duly appointed presbyter in charge of the Shillong Presbyterate, as well as ex officio president of the Shillong Pastorate Committee, along with all the rights, interests, roles, duties, and responsibilities. So that is his, my lord, substantive relief, that he should be declared the rightful presbyter in charge, and by virtue of his position, he is the ex officio president of the Pastorate Committee. This is the substantive, my lord, the main relief. Other are the consequential. Now I'll take my lord to the compilation. What happened?
To the
compilation. Subsequent suits filed. 1 and 2. My lord, so far title suit 1 of 24 is concerned, my lord. This was filed on, my lord, 12/3/24. 12/3/24, your lordships. If I can take my lord to page, what? Sorry. If I can take my lords to the running page 32. In fact, it starts from 31. Lordship. The prayers.
Yes.
I just read it. In view of the above stated facts and circumstances, it is therefore humbly prayed that your honor may be graciously pleased pass a decree in favor of the plaintiff against the defendants, same defendants again, my lord. The declaration that the plaintiff is the presbytery in charge as well as ex officio president of the Shillong Pastorate to be allowed to discharge his rights, rules, duties, responsibility in connection with the election. So, my lord, is substantially, my lord, what is the relief sought for in the one which they sought for transfer and this subsequent petition, my lord, same, this substantive, because other relief, my lord, consequential relief depends on this. But that is how he made his case, your lordship. I filed it before the trial court. Now, my lord, ultimately what happened, your lordships? The page. This was withdrawn, my lord. He sought and withdrawal with the permission to file afresh. Now, this is a civil proceeding. The court has reservation. No steps was taken for service of notice on us. So, court raised an objection, my lord, of its own, that without hearing the other side, we cannot give you a liberty. It could be at best withdrawal simpliciter. Now, well, it has a huge consequence. I'll come to that. Now, where is that order? 38. It's just 3. Page. My lord, page 37.
Yes.
37, your lordship. 37. Case record for learned counsel plaintiff, he informs the court that he would like to withdraw the present suit as there are some defects in the plain connected document. Then the application neither mentions the provision which the application has been filed, nor does the application mention the nature of the defect which is compelling, and the plaintiff filed the present application when Thapa submits that some annexes are missing and that the court should pass an order fast. Furthermore, the application mentioned the wrong suit in cause title as well in the body of the application title suit such and such. Given above, the application filed is rejected. Plaintiff is at liberty to file the application under correct provision of law. So next page, your lordships. Case record is put up before me such and such. He filed miscellaneous case number 3. Now this was fixed and this was decided, your lordship, on 28, my lord, the next page, 39. Now this was also again refixed, my lord, the matter. Now the 40, effective order is at page 40 here. Now this say, my lord, case records put up before. In view of the order in the miscellaneous case number 4, wherein the plaintiff petitioner was allowed to withdraw without liberty to file afresh. Title suit number 1 and its connected miscellaneous cases, the present title stand disposed of, is withdrawn. Now, these has a huge consequences. Now, he is admittedly one relief, which is also included in the present plaint, declare him as the presbyterian in charge.
No, one thing, Mr. Sen, suppose the case is transferred there. Suppose the case, has been transferred before he filed the other suit, right? Suppose coming here in motion stage itself, fine, since the matter transferred, since the lack of jurisdiction is apparent of the record. Now, if it filed a second suit also, it will be barred by section 10 of CPC. So then at the time you could have filed it, but you filed stay of the suit. The second suit will have no consequence. What is important is that the first suit, whatever is this 27, right? Before is still alive.
No, my lord, I'll just.
And the proceedings have been stopped by this court. So this court can't go on stopping the proceeding. It has to go somewhere.
No, my lord, what I am saying.
You are seeking a dismissal of this transfer petition.
No, my lord, I am coming. I'll just come to it, your lordship. Sometime.
Yes.
No, my lord, civil matters, your lordship, because the entire thing is covered by, my lord, the CPC. Now, what your lordship correctly pointed out, if notices were served on us, taken steps, perhaps we had to gone before the court and filed an application, my lord, for stay under order, section 10.
Yes.
Already the issue is pending. Notice were not served. He tried for a, my lord, without notice, initially he tried for a withdrawal with liberty. That was not allowed. Ultimately, what was allowed, your lordship? Simpliciter. Now, under 23, it has its own consequences. What are the consequences? Very clear. If you abandon your claim in a suit or part of the claims, then in respect of that abandoned claim, you cannot bring and cannot rehesitate it. So, my lord, this is what happened. Now he filed, your lordships, another suit, my lord, that is title suit number 2, your lordships, on 13/3/24.
Yes.
If I can take, my lord, to the
page,
my lord, page 111.
Yes, on 13/3.
Yeah, 111.
111.
111. 111. Now, what it say, your lordship, I read? For a declaration that the plaintiff is the presbyterian in charge as well as the ex officio president of the Shillong Pastoral Committee and shall be allowed to discharge. My lord, ditto same, my lord. All these three, ditto same. Now, again, my lord, with other consequential reliefs.
And what the order pass?
No, my lord, again, your lordship. If I can take, my lords, to lordship will be come to page 122. 122, my lord, dated 34/20. Case record is put up before me on call in view of the order of the miscellaneous case number 6, wherein the petitioner such an allowed to withdraw without liberty to file this. Title suit number 2 of 24 and its connected miscellaneous case, the present case, stand disposed of as withdrawn.
Which miss case is this, number 5?
Miss case, my lord, he filed a case, formal case for withdrawing. For withdrawal. That has been registered as miss case. So that same, my lord, the plaint was allowed to be withdrawn, my lord, but without liberty. Now, here the problem starts. This is governed by the CPC, your lordship. Because here, what I want to point out, your lordships, what he was trying, this is a classic case of forum hunting. They tried here, there, this matter was pending here. Unable to get an order, somehow it was withdrawn. Now, my lord, they are trying their luck here.
But while the matter for transfer is pending, why you go around these adventures?
Lordship, there were fresh
Why?
causes of action, even defendants were different.
No.
Lordship, may kindly see, Lordship. I explained, Lordship, that on...
I know, let Mr. Sen finish.
Lordship,
But it's complete, I mean, this is your abusive process of law.
Lordship, I'll try to satisfy, Lordship.
Lordship, now, my lord.
Yes.
Now, my lord, in the meantime, there was no injunction, nothing, your lordships. Fresh election was notified, and fresh election was held on 17th March, 2024. A new body was constituted, pastorate committee, along with all other office bearer, and they duly took over charge, my lord, on 31st March, 2024. And so far, their recognition was concerned, my lord, this was done way back in September last year. Now we are almost 1 year hence. None. Now, my lord, in the situation, he filed a fresh title suit after the results were declared, charges were taken over. He filed a fresh suit now before the assistant to district judge. Assistant to the district judge, my lord. There, what is his prayer, your lordship, again you will see. But there, of course, my lord, I have filed my written statement and I have taken up all these issues. Perhaps that could be. But even then, for your lordship appraisal.
Title suit number?
Title suit number 16 of 24, my lord. That was filed on 27/5/24. If I can take my lord to page 200. Yeah. My lord, the prayer is at the lordship, page 222, 222. For a declaration that the plaintiff is the presbyter in charge as well as the ex-Sugar president of the Shillong Pastorate Committee 24/7 and shall be allowed to discharge his right duties. Dito, all these things are dito same. And so far this is concerned, we have filed our written statement, lordship, filed our written statement, filed our show cause. At least these case, my lord, I thought my learned friend is very serious to pursue for an ad interim injunction. So what happened, my lord, certain facts I should bring to your lordship notice. When this matter was, my lord, we enter a file a caveat, filed our written statement.
This matter is pending.
22/4/24, my lord. What happened? That day, we could not file. So we were, my lord, we were ready for an ad interim, the huge press anticipating. But also, my lord, made a formal prayer, some more time. Now, that was not objected. Instead, my lord, he placed the documents before that court, which turned out to be an FIR. And his submission before the court that this is an FIR on behalf of the pastorate committee or charge, drafted by senior counsel Mr. Chakraborty. And since the judicial officer concerned, at one point of time, practicing along with him, he did not say recuse. So he says, I brought it to the notice of the court.
Who is the assistant to?
My lord?
Practices who the assistant district judge?
Assistant district.
Practice along with Mr. Chakraborty.
So he did not say recuse. I formally objected. What is this? I said, give me a copy.
No one recused, Lordship.
But he pointed out that this is a document pointing out this is drafted by Mr. Chakraborty. And Chakraborty is the senior counsel with your honor at one point of time attached to his chamber. That's what he said.
Okay.
So, my lord, I objected, my lord, what is the position of it? Of course, that court said you come up with a formal application. No order is in this regard. So far I am concerned, I said I'll examine how it has a bearing on this. So he was not interested at all, my lord, for an interim order. This is what I am trying, my lord, to show is.
So now, Mr. Sen, you're saying that by transferring this matter, it will be redundant, you mean?
Redundant, no, lordships. Very. And other thing also, some law, my lord, some.
But let the court take its call. We're not going to go into the merits of the matter with regard to the claims and counter claims.
No, lordship, my lord.
We understand. We can pass orders, but the thing is that it's under transfer. It's not even under 227 or something like that. Yes.
Now, other thing your lordship will point out. So far, this after filing the written shockers, my lord, caveat discharge, my lord, till date, my lord, nothing happened. Not a single date, my lord.
Why are you avoiding? You don't want the matter to be taken up.
Interim injunction.
Lordship, they had filed their written show cause on the last date. I had prayed for 1 week's time. However, unfortunately, on the date when it was raised, I had some bereavement at home, which is why it was
No, why objecting to the forum, to the judge also? Lordship? After yourself consciously you went and filed it in the.
No, Lordship. In the pendency of the matter before the learned assistant judge, an FIR was filed by Mr. Chakraborty. And
what's the FIR about?
FIR is regarding this issue only of manipulation of fund by the bishop and so on and so forth.
By you?
By me and the bishop and the other functionaries of the church. So I, Lordship, thought it fit to place it before the judge. I had not prayed for any recusal or
Mr.
any.
Goti filed as a lawyer or as a...
He is a member of the
member
committee.
of the
He is a
church?
member of the committee. And I don't want to go into any submission of those.
Whatever is does
How
not
it is relevant? Those are besides the point. I just thought it fit to bring it to the notice of the learned judge.
Now, my lord. Now, my lord.
Learned judge has not recused. And we have no
Proper
objection.
respondent, my lord. The bishop. Mr. Jindal and now my learned friend is represented. You know, who is this bishop, my lord? Michael Hannes. The man who, along with the petition, that is what, Lordship may not go into it, like to go into it, who, along with this petitioner, my lord, helped to convert a heritage site of Shillong, my lord, into a complex, business complex. From there, the problem starts. Lordship may not go into it. And as on date, my lord, he is a bishop of entire Northeast Diocese, my lord. As on date, my lord, he is, my lord, mismanaging the church property elsewhere also. Right now, my lord, I have taken up this before the trial court. He is on an anticipatory bail, obtained from Guwahati.
Anticipatory bail?
Anticipatory bail, on misappropriation. Now, my lord, I have taken up all this point in the written statement before the assistant to district judge. Now, coming back, your lordship, to the judgment, my lord, it's very unfortunate, I'll say. This is the 2-page I have got. DAV College. Now, my lord, general principle from day one, lordship is fully aware. What are the general principle for transfer? For the ends of the check is very soft, can be transferred. Now, paragraph 12, only, my lord, is a recitation of the section. Now, this case, my lord, when I went through the entire judgment, ultimately what the court did, a number of transfer applications were filed. All these transfer applications, prayer for transfer application was rejected by Supreme Court. Read that paragraph, my lord. And he said, in the matter of transfer, we leave it to the trial court. Go ahead. I'll just read paragraph 15. He supplied me only 2 pages, not even the complete judgment.
Who supplied you?
That day, my lord, this was what was given to me. I don't know, your lordships might have got the complete.
Yes. I put judgment. 2010 all this one just extract.
Seems so, Lordship. It's only
where's the general?
Of a page and page, paragraph 12.
There also, I think, 2 pages, your lordship.
Yes.
2 pages, yes.
I don't know, my lord, why lordships. No, well, I understand, lordship understand very well, very fast, the lordship asked me. I would not have filed this affidavit. All these developments were not there. Now, lordship said, these are the principles, and what the Supreme Court said in paragraph, that principle, and what it said ultimately in paragraph 15, your lordship, the citation I am giving you. Citation 2010, 8 SSA 401. I just read my paragraph 15. Lordship got it at page 406.
Yes.
We are also satisfied that it would be far more practical and in the best interest of the parties that the proceedings are conducted in Delhi. Further, if the petitioner claim is accepted, it would open a floodgate for similarly placed person infringing registered trademarks approach this court to transfer the suits to the location convenient to themselves or all over India and defeat the purpose of 134 of the Trademark Act, which confers no jurisdiction with respect to registered trade. Since the issue relating to jurisdiction, particularly whether the court at Delhi has jurisdiction or not, is to be decided by the trial court. We are not expressing any other thing on merit of the case. So this case is slightly different. Lordship, whatever he said, it has been left to the trial court.
No, this is different. Whatever is, but in this case, Mr. Sen is confined to one case only. This case is a series of matters where again trademark infringements.
I have other decisions.
Like for uniformity, you don't transfer it, but this court lacks inherent jurisdiction.
My lord, what I want
anything.
Yes, I got. What he pointed out, my lord, only the general principle. General principle, lordship got it very fast.
The only thing for you is to get the plane returned.
Exactly, my lord. Plane get returned.
The plane gets returned, but will not do it from this court.
Yes. What I want, your lordship, that will amount, my lord, even after placing all those things, my lord, if your lordship transfer, these will have some kind of approval, my lord. My humble submission.
Kind of?
Some kind of, my lord, in spite of, my lord, is a case of, my lord, forum hunting, he's trying here, there, everywhere, your lordship, kept it pending. If he had managed some kind of injunction order, he would have come and withdrawn it. That's what was his.
See, what we'll do is we'll record all those. We'll record a sequence of events and how this petition plaintiff is, in fact, has it's infringing on the abuse of process of court. So that is noted by the court. But with regard to that, it go back and let the trial court pass appropriate orders on when the matter has been transferred, because it's the same forum. Munsif and I think and the assistant to deputy commissioner, the same court, correct?
Same presiding officer.
Same presiding officer.
No, my lord, one more
Is
thing.
it very different hat?
And some judgment, my lord, High Court judgments. Now, High Court says one thing about, my lord, 24, section 24(5), is the discretion of the court.
Discretion of the court, but then like we have to look, it's a question of, see, the base question here is, suits been instituted in a court of lacking complete. Now what he's done is he's manipulated the system using his advocacy skills. Mr. Depp has, his sharpening his skills, especially civil law, which is, you can do whatever you want. I think what he's done, he's sharpened his skills. Firstly, first scratch his, brains and sharpen his skills by, he knew that his case is nowhere. So what did he do? On a date fixed for hearing of the injunction matter, he comes before the High Court and says, this I need transfer because not fine. And then this court also on submission says status quo of proceedings. Proceedings at standstill. So while at standstill now, he starts hunting. He goes again to the forest and tries to grab, it doesn't work out. He goes again after another, another prey, doesn't work out, So now he's left with no other recourse. Now before the assistant district judge also, he's gone there, then he finds that maybe it's not suitable. He said that that presiding officer is a junior of whoever filed the FIR. Now again, he's come here, there's only his last, like you say, clutching the straw is to get it transferred there. Maybe it's some flame still is, he can still ignite some flame. But then we will make observations.
If I may,
is that a question? But you can't preclude the court to make observations.
No,
you should transfer the matter.
Absolutely.
But these are the conditions that the court take into consideration.
If I may make a 2-minute submission on that.
I have not finished. My lord, some decision of the, my lord, different High Courts, your lordships. No, my lord, I will start with, my lord, decision of Allahabad. That is often referred to in almost every digest and journal. Where is that? Allahabad? Allahabad. This is, yes, my lord. Allahabad, that is 1985, SSC online 794. That is, my lord, specifically with regard to, my lord, 24.
1985 SSC online.
Online, Allahabad 794.
Yes.
Now, relevant paragraph, my lord, starts from paragraph 10. We can read paragraph 10.
Yeah.
The Learned Counsel for the revisionist, however, has placed specific reliance on subsection 3 of section 3. His argument is that since the code of additional and assistant judges are deemed to be subordinate to the district judge, this by implication means that district judge cannot transfer an application under section 24 to the code of additional district judge. In my opinion, this argument is fallacious. Now here, my lord, the same power district judge also can exercise for transfer. There it was placed before the district judge, 24/5 to.
But the thing is that these are under 37 rules. Assistant Deputy Commissioner.
Lordship.
And Munsif under Total Shillong Civil Courts Act.
Lordship.
Those two different jurisdictions altogether. It's not, it's not, you understand that.
Yeah.
They are different. It's all lateral. They're lateral proceedings.
Yes, that's why it's
vertical, like parallel proceedings.
Yes. So, my lord, it is in that context. Now, ultimately with 24/5, what it held. Now, my lord, I'll just continue reading. For the purpose of subclause 3 of section 24 of the CPC, it's clarified that even where a matter is pending before the additional and assistant judge, then the district judge will have the general power of transfer and withdrawal, as the additional and assistant judge in such a circumstances shall be treated as subordinate to the district judge. This is only to avoid the moving of every transfer application.
No, this is all going to apply.
No, it's not.
Because it's parallel jurisdiction.
Lordship will kindly come to 11. Paragraph 11.
It's a parallel jurisdiction.
Under section 24, clause 5, a discretion has been given to the district judge to transfer a suit or a proceeding from a court which has no jurisdiction to try. It is not mandatory. It is in the instant case, additional district judge has made an observation that the revision can move an application to the court concerned for withdrawal of the suit with permission to file the same in the court of competent jurisdiction. I do not find any error in the observation made by the additional district judge. That's what my lord. This is a discretion, my humble submission where this series of acts has happened, your lordship. Lordship, my humble submission, lordship will not exercise the jurisdiction, my lord, and transfer the case. Now, my lord, similar judgments are there, your lordships, in. It is a very short judgment, my lord. Similar. There is 1985 SSC online, Punjab and Haryana 578.
Punjab?
My lord, 1985 SSC online, Punjab and Haryana, page 578.
576.
578.
326. Page of 578.
578. Well, if you can read, it's a very small judgment. The plaintiff respondent, paragraph 2. Plaintiff respondent Anil Kumar filed 2 suits against the defendant petitioner Hari Ram in the court of subordinate judge at Hazar. The defendant moved to transfer application separately before the district judge Hazar for transfer of the said suit from the court at Hazar to the court at competent jurisdiction of Fatehabad. The main ground urged for seeking the said transfer to the suit before the district judge was that court at Hisar had no territorial jurisdiction to entertain the suits, and therefore the same be transferred to Fatehabad, where the court had jurisdiction to try them. This submission did not find favor with the
So you want the court to leave it to the discretion to go for the district judge?
My lord, is it the discretion of the courts?
See, what our jurisdiction doesn't mean we are in parallel jurisdiction. The thing is that it's under 37 rules. That means we, it's in, and the assistant deputy commissioner will go to additional deputy commissioner and appeal under 37 rules. And if it's Munsif, it's under the Shillong Civil Court Act. So I don't think these judgments will be.
No, my lord, my lord, from this decision, my lord, when lordship has noticed all those things, my lord, this
We
is the
notice
case.
that, Mr. Sen, the court deprecates the conduct of the.
No, my lord, other thing.
But by applying the law.
Now, my lord, other consequence, your lordships. The day he came, already my application, as well as my lord, from the lack of jurisdiction, my application under Order 39, Rule 4 for discharge of the injunction was pending. Now, my lord, I have
no
an
injunction on date.
My lord,
there's no injunction.
No injunction, sir, but it was there.
There's no.
It was there.
It is over till 7.
it's over.
Then
Now
that argument will survive because there's no injunction.
No injunction,
Date,
but-
number one.
but I'm just saying-
the only operative part of the order of this court is that the subsequent proceedings. That's why you're stuck there. That's the only thing. So if the status quo order proceedings are there, that matter will be heard by now.
Now, lastly, my lord,
And the plaint will be returned to him.
Yes. Lastly, my
You
lord.
will have to withdraw.
Maybe, Lordship.
You have to go and withdraw now the suit. You have no choice.
Lordship, that is why I have come with the transfer, Lordship, that because at the end of the day,
we will remark that.
Lordship, please, because
last one,
We're remanding it back to the court of where you inserted the suit.
Before I conclude, your lordships, one submission is there.
Yes.
Now, my lord, if your lordship direct transfer, now there is a difference between, my lord, transferring a suit and, my lordship is aware, my lord, and, my lord, returning the plaint. If the plaint is returned, and if you represent,
I was just toying with the idea of not transferring the suit to the court. I was toying the idea of you finish your applications first before on jurisdiction before the court, which is trying the case right now.
Yes.
That's the court of assistant deputy commissioner. You're alive. You accept.
my lord, let him contest. Let him contest. Should contest.
why, Lordship, I have some reservation. Because, Lordship,
Why this court reservations? Because it was simple transfer petition, no reservation. But the manner in which you have conducted yourself demands that you on jurisdiction you should be heard and whether
Lordship, if I may submit, Lordship,
Yes.
if my Lord Senior is done.
My lord, I have not finished one last point. I will say
Very
that.
well.
Yes.
Last point. What? Here, my lord. Problem. Here, what happened? Lordship has seen his conduct. Now, my lord, there is a huge difference between, my lord, returning a plaint and transferring. If it is transferred, then it will be treated as continuation of the suit from the beginning, my lord. There is no. If the plaint is returned on presentation, my lord, it will start afresh. Now, I get and I should take up the plea of misuse and abusing the process of the court. I will point out, my lord, if it is presented afresh, obviously I will point out, my lord, now similar claim, 2 suits were filed, they were withdrawn, my
return
lord.
of the plaint will be at the instance of the trial court itself, not from here.
Lordship, my lord, but that will be taken away from me. I can argue, my lord, if it is presented afresh, I can argue, my lord, that on the same claim 2 suits were filed, they were withdrawn without permission to file afresh. So this was hit by 23 Order 23, Rule 1, where my lord said if it is withdrawn without liberty to file afresh, then precluded from rehesitating it. But if your lordship transfer, my lord, in spite of his conduct, my lord, then it will be the continuation of the proceeding. So my humble submission, my lord, here your lordship will not exercise the discretion. Send him back, my lord. My lord, if he can satisfy the court, your lordship, that court has the jurisdiction, my lord, he is at liberty, my lord. Otherwise, other thing will follow, your lordships.
So you leave the court of quandary whether you transfer it or remand it.
And my lord, it is a case, another thing, last one thing I'll touch, my lord, approbate and reprobate. My lord, what is this, your lordship? Till we file, had it been a case, my lord, that before we filed on question of jurisdiction, he is coming and seeking a transfer, matter would have ended. When he raised the question of jurisdiction, and he was, my lord, served a copy, and my lord, he was supposed to participate, my lord. Then he came, and here also your lordship is conduct is not authorized, my lord. If he had come about that, I have noticed this, I am coming here before any party is prejudiced. Now I will be seriously prejudiced if your lordship transfer this petition. So my humble submission, my lord, this is a classic case, my lord. Normally this kind of should not have been, my lord, objective, but because of the development, your lordships, my lord need not transfer, instead send him back there. That's all.
Let me take 2 minutes, lordship. Lordship, my first submission is, lordship, that just
on law only.
On law only, lordship, that I have not filed any fresh suit for the same cause of action, whether withdrawn or pending till date, lordship, because they were fresh causes of action, and lordship may be pleased to.
No, that we've noted.
Peruse the compilations also.
That, but the manner which conducted yourself is, that is one thing that,
No, lordship.
Litigant should come before court, with, like they say, with clean hands.
Absolutely. Lordship.
This is my grievance. Like you come to court for relief. Now, it's not meant to be used as the cover,
Absolutely. Lordship, kindly see, lordship. The first suit which was filed in the wrong court, an injunction was passed in my favor for a limited time, for which I have sought for transfer, lordship, had nothing to do with the developments which happened from the year 2024 onwards, lordship. The first suit which was filed and withdrawn was, as I stated, lordship, in a principal challenge was laid.
Now, okay, coming to another part.
Lordship.
Suppose the suit is transferred. Does your cause of action survive?
Entirely, lordship, because lordship kindly.
How?
What has basically happened, lordship?
Elections have already happened.
Lordship, yes, because
Now the only thing that your fresh cause of action has arisen.
Lordship, yes, that is in connection with the new committee.
You can only take reliance of the events that have happened before. Now, if you file a fresh suit, you have to take account of fresh cause of action. There's a new committee in charge.
Lordship, yes.
Then there's a new presbyter in charge now.
No, that is.
That has already happened. If the elections have happened, has happened.
No, because that is why, lordship, I read out para 2 of my petition.
You appoint someone else.
Presbyter in charge is not elected. Presbyter in charge is not elected. Members of the committee are elected, lordship. Presbyter in charge is not elected. He is appointed by the diocese. And
by whom? By the committee?
By the diocese, lordship. By the bishop. By an order of the bishop approved by the synod situated at Delhi. Now, lordship.
So the bishop operates independently of the committee?
Yes.
You are independently?
Yes, lordship.
That means
over and
above the committee.
Over and above the committee. And in fact,
suppose the committee decides anything, he has no role to say.
Yes, in fact, lordship, if I may just take your lordship through some of the meritorious aspects, lordship, all these resolutions which have been challenged by me in the first suit, lordship, from June 23 to September 23, they were all certified, or so to say, lordship, stated as to be null and void by the diocese and the synod, which is the apex body of the church. Now the committee, for best reasons known to them, instead of accepting the letters by which the diocese and the synod has said that, see, this is not as per the constitution, they are null and void, they have in fact gone into lodging FIRs and going against the bishop, and so there were other aspects. Now in the meantime, lordship, what has happened? The secretary who has been creating all this ruckus has been suspended in the month of March 24. In July, he has been terminated. Those are all there, lordship. Subsequent developments have come. In fact, today also I saw a newspaper report regarding the FIR in Guwahati, which my learned senior was talking about. So, lordship, it appears with all fairness, lordship, it appears that the church is not functioning in a religious harmony, so to say, lordship, and there are some disputes are there.
There's nothing, religion has not come into play at all.
Absolutely.
All it's administrative.
Yes, because these are in connection with administrative issues. And presbyter in charge, lordship, he is not only an administrative person, he is also the spiritual leader of the church, along with the bishop. Now, those are all there, Lordship. There are, if your Lordships are pleased to go through the suit and all the other suits and all, Lordship will see various contentious issues are there.
Contentious issues are there, but the thing is that the way you manipulate the system, that's all.
Lordship,
what this court does not look at it favorably is that when the matter was picked on 7/12 on the issue of jurisdiction, instead of contesting it, you sought, a roundabout way and sort of transfer. That thing, yes, that is the tentative the court will go against you.
No,
That's the thing. And so whether transfer is discretionary, now whether we send you back, I think we'll decide.
Only one submission, if I may make, Lordship.
Yes.
That they filed an application under Section 21, Lordship. Not under Order 7, Rule 10, firstly, asking for return of the plaint. When the application objecting to the jurisdiction was filed before the trial court, admittedly, Lordship, prima facie, without, I cannot go beyond, it was filed in the wrong court, Lordship. Trial court took cognizance of the matter, granted me time to file a show cause, and yet extended the interim order in their presence. On the same day, Lordship, I had referred
See,
this.
what happens in such cases? You don't need to seek transfer also. Transfer is sometimes in a different context. So inter-district.
Lordship, yes.
Then you seek transfer.
Lordship,
suppose husband staying here, wife is staying there.
Yes.
He goes before divorce suits for the transfer. In those cases, now in your case, it's not I'm sitting in the advisor capacity. What is normally done is just that your suits find the wrong forum. You file an application. Not wrong, the plaintiff returned to you, you take liberty to present it in the court of competence.
Absolutely, Lordship.
Simple as that.
Had the learned
but then you have not done that. You have realized that after on jurisdiction that has come now by admission. You have admitted by filing a very petition file here. You have admitted that the court where issued the suit does not have jurisdiction.
Lordship,
so what prevents you from? It's a question of this court exercise discretion to say, okay, fine, transfer it.
Lordship will kindly see, Lordship, that the language, the very purpose of
orders then, yes.
Lordship, the very purpose of putting Section 24(5) by way of amendment into the CPC was to save this kind of situation, Lordship.
Yes, not to excavate it.
Absolutely not.
In the way that it's been done.
So my only humble submission is, Lordship, the Order 39 application may be decided on merit by the trial court.
In such orders.
It may be transferred, Lordship. It may be transferred. Because return at this stage, Lordship, will be heavily prejudicial to me, Lordship. And only because I have not, or the learned trial court has not adopted the procedure under Order 7, Rule 10, and in the meantime, Lordship, this Honourable Court has taken cognizance of the matter under Section 24. Lordship, that is a question of technicality.
So we'll do one thing. We'll transfer it on one condition.
Lordship.
That the suit starts afresh.
Fresh, because as your Lordships have observed that in view of the status quo, the injunction may not survive as on today. I don't want to make any submission on that, Lordship, because then again an argument will start whether it survives or not.
No, see, give special directions that we'll allow the transfer.
And let the
make it very simple. No, we'll allow the transfer
Lordship.
to the Court of Munsif, and it starts again from square one. All the orders pass earlier on, and even think that the order of the Court of Munsif will go, but then all orders stand negated, and you start from square one.
So if I may make only one submission, Lordship, the position may be restored to the position as of 24th November.
No,
before the order was
When was the suit filed?
Suit was filed on 22nd November.
Right. As of 22nd November, the suit is, let them take it afresh.
Which is, Lordship, which is what would have happened normally also, because only two...
No. Usually the suit starts up from where it stopped.
No, absolutely, Lordship. My prayer in this transfer was to transfer it from the stage of 7/12.
Yes.
Lordship is not inclined, I understand, Lordship. My only submission at this stage, Lordship, is that the order of 24th of November passed by the learned trial court is only on a very limited, Lordship, that I should not be kicked out of my house and I should be allowed to do my duty to a limited extent. That may be adjudicated on merit, Lordship.
That is open. Your suit will be transferred. Your prayer is there.
Lordship.
It's not a question of you withdrawing it and restructuring your prayer in your new suit.
Same prayer.
You have to go by the same prayer.
Same prayer, Lordship. Same prayer. So,
Lordship,
Lordship,
said that way, Mr. Sen. We'll pass special directions.
My Lord,
start from square one.
Lordship, only thing I am saying, my Lord, in cost of repetition, I'm sorry, Your Lordship.
Cost?
No. At the cost of repetition, Your Lordship.
I thought you wanted...
What I am saying, Your Lordship, the level of abuse, Your Lordship, my lord will not exercise because this may sadly, my lord, encourage others.
Let me just give a fair assessment, which is outside the the deliberations. We are sending back to the poor old court, which is already trying the matter, wearing a different hat. Why should he be burdened? This is already well versed in the matter. Let him handle fresh the food. That's it.
The only thing, my lord, this should not set up a precedent, your lordship. Because the others will.
How is it a precedent?
My lord, the way he abused your lordships, and now he is seeking transfer,
17.
your lordship. So my humble submission, lordship will not exercise this.
Yes.
Let him go back. Let him.
It's as good as going back. If we start afresh. With what question directly? You agree with that? Yes.
Nice.
May I be lordship?
Finished from the Supreme Court.
My lord.
What happened? Order was
My
passed.
lord, it is likely to be listed tomorrow, my lord, in Supreme Court matters.
But they said that the arguments are complete in Supreme Court.
Service has been completed in Supreme
What
Court.
argument already? Because there are the hundreds and thousands of petitioners who are respondents, but there is still the notice is being served.
Okay, will you when? After?
After 4 weeks or 6 weeks?
Just a matter of 4 weeks. You have to await further information about the matter pending for novels before the Supreme Court. Yes. Why do you have to wait for so long just for that order? Yes.
17, 18 connected matter, my lord.
17, same order.
22.
Repeat, lord.
Oh, you're waiting for the transfer matter.
Well, this is a transfer.
My lord, we are required. I could not go through the file, my lord. Yesterday I came.
That cannot be permitted, my lord.
My lord,
But this is a very clear-cut case, my lord. My lord, he
hasn't finished his submissions. He said, I've not been able to go through the fight, but the matter can be taken up now, right? No.
No, my lord. My lord, yesterday only I came from there due to some personal
Treatment.
difficulty. So, my lord, that's why I could not go through. Otherwise,
Tomorrow was fixed matter.
my lord.
Mr. Jha, Mr. seek some accommodation as he just want a station. This matter tomorrow. It's up to me list as a fixed matter. Tomorrow we'll finish it off. You've enjoyed enough. How long you've enjoyed the stay order?
4 years.
4 years.
No, man. Not that. The writ petition was filed in 23, my lord. Writ petition was filed for 4 years. How it can be, my lord?
Although in total, he's for last 7 years he's in Shillong. Again, the norm of 3 years.
Yes.
Twenty-three.
Can you satisfy that point?
Yes, I have.
51B.
I have done some research. Your
Very
Lordship.
good. MDRI.
Your Lordship. Last occasion we have left with the provision of section 5(1)(b). Satisfies such condition as may be prescribed. Then I was looking to section 3F.
5(1)(b). What's 5(1)(b)?
Prescribed mean prescribed by rule made under this act.
Section?
Section 3F. 3F. Then I was looking, Your Lordship, to the provision of section 15, 15A, and 23C.
One second. Yes, what are you saying? Sorry.
I was looking to section 15, 15A.
Now, why you
23.
say first come? You just cited. You said 3F, correct?
Yeah, that
3F
is
says,
made by rule.
Prescribed is prescribed by rules made in this Act.
Yeah.
Now,
under the Act.
51B says.
It is a state government power to make rule in respect of minor minerals.
Satisfied such conditions and may be prescribed.
Prescribed, yes. Yes. And those conditions, I may look again to, I am referring one by one, Your Lordship.
Yes.
Then section 15A, power of state government to collect fund for district mineral foundation. 15A, Your Lordship.
Am I sharing job? 15A.
Yes, 15A, Your Lordship.
15?
15A.
15?
15A, capital A.
15A.
Yes, Your Lordship.
The person by whom the manner.
Yeah, that one, it is a power of state government to collect fund for district mineral foundation in case of minor mineral.
We want to concern minor minerals here. Here we concern with major minerals. Yes.
Then again, 23C.
So minor minerals, we want to concern minor minerals.
Yeah, Your Lordship.
Yes.
23C.
Yes.
Power of the state government to make rule for preventing illegal mining, transportation, storage of mineral.
Yeah.
Then I will look to section 13. Power of the 113. Power of the central government to make rule
Yes.
power of state government, central government to make rule in respect of mineral. And under this provision, Mineral Concession Rule 1960 was framed by the central government, Your Lordship. I will look to section 13, clause F, E and F.
One second. Let me get a pencil. Yes. Okay. Now, first he said section 3F.
Yeah.
F
3F.
Meaning of 3F, right?
Yeah. Prescribed means prescribed by rule made under this Act.
Okay. Meaning of prescribed.
The second is power of the state government.
Now, next is you cited, you said section 15.
15A and
15A is only with regard to rules for minor minerals.
15.
Rules for minor minerals, right?
Yes.
Yes. Minor minerals.
In those,
now,
my submission
next
is
say that is
13.
Next is 13.
Power of the central government to make rule.
13, that is 13A.
Yeah,
13, sorry. Power of central government, yes. Power of central government to make rules.
Yes, Your Lordship.
Then you come to 23, you say.
No, 13 F, close
13?
F. 13 2 close F.
13 2 plus F. One second. 13 2 plus F.
Close F. The procedure for obtaining reconnaissance permit, a prospecting license, or a mining license in respect of any land in which the mineral based in a person other than the government, and the term in which and the conditions subject to which such a permit, license, or lease may be granted or renewed.
Okay. Yes. Let me set
Then-
15A,
then your lordship,
13, yes.
I will come to that State of Meghalaya versus all the Mesa Student Union.
Para 91.
Para 195,
Yes.
subparagraph 7.
I already must have. Para 95.
195,
195.
195.7.
And
It reads, I think, the statutory scheme delineated by section 13(2)(f) and the Mineral Concession Rule 1960 clearly contemplate grant of mining lease with regard to both the category of land, that is land in which mineral based in the government,
you say paragraph?
and 195.
Point?
0.7.
0.7, you say that, yeah. The statutory license scheme delineated by section 13(2)(f) and the mineral concession rule, gram mining, the board doesn't comment. Yes.
Yeah, they say that based in the government, the land in which mineral based in the government, and the land in which mineral based in a person other than person. That provision apply for government and for the private land also, your lordship. That 13(2)(f). Then, your lordship, condition of prospecting license already defined by the central government under mineral concession rule. What are those conditions? Section 14, Rule 14, your lordship. Or prospective license. And Rule 22, application for grant of mining lease. And condition for mining lease, Rule 27 of Mineral Concession Rule 1960. Again, I refer to Rule 22D of the Mineral Concession Rule. The size of
No,
mining
okay, fine.
lease.
Please let us retract our steps. Now come back to what you mean by, court had put a query.
Yes.
That under section
Condition.
5(1)(b),
Yes.
the state has the power to prescribe certain conditions, correct?
Yes.
Yes. Now, your
point is
argument
that-
is what? You say prescribe has to be by rules.
Yeah, prescribed by rule. Then my point
Now,
is,
what is the nature of the prescription given by the state?
it should be limited.
No.
Provision.
What is the nature of that document which they've given? According to you, what is that document which you said it is without jurisdiction?
The document I
That
will
would be challenging.
to the notification, your lordship.
Yes?
I am
Notification,
referring to the notification issued by the respondent.
Right. Now, what do you say? You say that?
They don't have power insofar that they are amending the Meghalaya or Mineral Concession Rule 1960.
This
I
is
will read
notification.
page 27 of my
This
petition.
SOP,
Yes. Let me
which
read
you
the,
challenge this impugn one, right? This
Yes,
is Annexure 1,
yes, sir.
page 37. This then opens for so.
I will read. The government of Meghalaya hereby notified standard operating procedure SOP for processing the application submitted under the Mineral Concession Rule 1960. And this rule, it is by the central government, Your Lordship.
Now, what is the nature of this SOP then, according to you?
According to me, it is beyond the rule-making power of the state government, Your Lordship.
So these ones not come with a definition of 5(1)(b)?
No,
According
it
to
does
you?
not find. Because where it does not count, this already it is within the central government. And this even SOP
The
also.
power SOP is with central government only. State has no power, you say.
No power. State power is only on those section, Your Lordship. On those section. Section 15, 15A, and 23A. In those provisions, there is no provision for state government to prescribe the area of 1 hectare area.
So you come back to para 91 and 92.
91, Your Lordship.
You read para 92.
91.
Para 92. With regard to the mineral policy that was drafted by the state of it, yes. Para 92.
91, it speaks of.
Okay, 91, his last part says that the review direction entities policy was made mining policy. Now come to 92.
92, yeah.
Yes.
Preserve of the entire policy document indicate that the policy has been framed by the state as per 19 Act and Mineral Concession Rule distinct.
Yes.
In
Now that the only question the court has is that whether this SOP can be considered rules or prescribed, or whether it can be seen as a prescription, which is as per the contemplation of the MMDR Act.
This one.
That is what. Now, if we read the Supreme Court judgment, it says entire policy documents. Now, this SOP is continuation of the policy that the government is putting in place with regard to the granting of prospecting or licenses for mining leases. Correct? You are agree with that. You're saying that the state, in this exercise of granting the money, has no power to prescribe the area because they have no power vested in them by law. Correct. Now, the state has made its SOP, which whether now we have to examine the nature of SOP, whether the nature of what kind of document is it, what kind of creature is it, whether it can be said to be a creature of 5(1)(b) and in line with the mineral concession rules. That is the only thing. And if you can show to the court that no, it is outside the purview of the mineral concession rules, outside of the MMDR Act, and not as given para 92 of Masa, then this SOP goes. Then the state does not have the power to prescribe this prescription.
For that query, Your Lordship, I will submit. If this mineral concession rule has empowered the state government, then an amendment has to be made the mineral policy, but not by a separate. But in this case, the power of state government to have that minimum area is lacking, Your Lordship.
Yes?
Is lacking.
Is lacking.
Lacking. because central government under Rule 22B has prescribed the minimum area 4 hectares in respect of all mineral deposit other than specified in clause A and B. I am looking to the para 91. They are speaking of Meghalaya mining policy, environment, for this. But in the last line it says, Your Lordship, however, the state in its mining policy can only include those areas where it has jurisdiction under the MMDR Act 1957 and the rule framed thereunder.
Yes.
And when the mineral concession rule has been framed by the central government and condition has been set up under that, and again a condition is making by the state respondent about amending this central mineral concession rule is beyond jurisdiction, Your Lordship. Above that one, they are amending, they are creating separate procedure and condition, which is beyond the ambit of the Act. Section 5.2 already specified condition, and the mineral concession rule has prescribed the condition for that, but not for the state government.
The one thing, Mrs. Sangma, is that you are not aggrieved with entire notification, correct?
No, I am not aggrieved by entire notification. Environment.
So you say that
pollution,
the state government has the power. A government has the power to issue.
Yeah,
such
because
notification.
there are separate acts to govern water.
Listen, one minute. So that means that you're not aggrieved with the entire notification, correct?
Yeah.
You agree only with that miscellaneous.
With that 100 only.
Only Mrs. Point 15.
Yes.
That means with the the competency of the state government to make this SOP,
Yeah,
you have no
100
quarrel.
hectare.
You have no quarrel.
No.
That means that these can constitute prescribed conditions which have to be followed. So what you agree
But
with
that
only,
also
only agree with the area.
Area, you know.
So then all the argument that doesn't hold, that means whatever you argue 3F, prescription doesn't matter.
Only
so you only
area.
feel that the prescription of the area is beyond the competency of state government, correct?
Yes. Only in the area, you lordship.
Only in area.
Yes.
And the thing is that you said that maximum rate has been prescribed, but minimum rates are never prescribed.
Never prescribed. And
That's only
central government already prescribed 4 hectare. And state government prescribing 100 hectare, you lordship.
So you have to show.
And
the
nowhere
code also.
in India has fixed this.
Nowhere in India is fixed.
No, no.
Now, don't you think that local conditions and other, like the situation demands that you make such, the small holdings, so they won't be, that is taking radical mining into consideration, whether it's reasonable, is a reasonable SOP that's been given, or you say it's discriminatory?
Discriminatory, not reasonable, your lordship. And all the
so you're confining to that.
Yes,
so you forget all that regarding the policy.
I forget all
they have the power.
Yes.
I'm trying to help you here, so we can condense the argument instead of going to 13 or 23 or rule making power, or whether there is as in line with mineral concession rules. We just have to condense the arguments to the reasonableness of the prescription.
Yes.
So you have to show that.
Yeah.
How it's unreasonable.
It is unreasonable because I look to the doctrine of reasonable classification under Article 14.
Yes, okay. Now we're getting somewhere.
Yes.
Yes.
It should be refer to a local.
Because of course, understanding, even this, you challenging the entire notification. That's your prayer.
Yes.
You say that part of entire notification.
Yes. Only 100 hectare, Your Lordship.
No, 1 second. Let's see your prayer.
Though I have mentioned that I will not press for other.
Where's your prayer?
My prayer is
So you're
this one.
asking for quashing the entire notification.
Yeah, but I will not press for other except 100.
You modify your prayer, you leave out A. That you only B.
Yeah, B.
Okay. So we'll start from there. You're confining your prayer only to B. Yes, to prayer B. Right.
It is discriminative in one way that those who have 100 hectare and below 100 hectare, it is discriminatory.
Show now.
Yeah.
You have to show in very uncertain terms
Why
how
it
it's
is
discriminatory
distinct?
and how is it scientific viable also. You see this reasonableness.
Yes.
Yes.
When we talk about the reasonable classification under Article 14 of the Constitution of India,
Okay.
one refer to a lawful and justifiable categorization of individual or group based on intelligible differentiatia that distinguish them from other.
Where are you reading from?
I'm reading from my note, Your Lordship.
Very good point, intelligent differential, yes. So this note is, yes, okay.
In intelligible differentiatia, the word discernible is there. Discernible. It cannot choose and pick up. Number two, the doctrine ensure fairness and prevent arbitrary discrimination.
Okay, that was a standard doctrine.
Yeah. Uphold the constitutional principle of equality and justice. It should be reasoner nexus.
No, exactly. You're making the closing point of the argument.
Yes.
I'm talking about the meat of the matter with regard to 100 hectares. Why is it discriminatory?
There is no.
Where
there
the
is no
intelligent
reasonable.
differential? Now you show the intelligible,
Yeah.
arguments that 100 hectares is feasible.
Is
whether the court can
unreasonable.
do that or not.
My point is unreasonable, 100 hectare, because they have fixed on what basis nobody knows.
Okay. You say that there's no, nobody knows means?
Nobody knows means
It's not
it is
fixed on
on
any-
paper only.
You mean it's not fixed on any
No.
scientific
No, no.
assessment? No.
No, cannot be.
Why cannot be? You can't make general arguments like this. You have to be specific.
So, according to.
You can't say, oh, I don't like that car because it's bad. You have to know. You drive
Why,
it, you know it's
why
bad.
I should say the Central Mineral Concession Rule
Yes.
has prescribed minimum 4 hectare. And the state government has prescribed 1 hectare.
1 hectare, 4 hectares, where is
Or
that?
100 hectare here. Sorry, Your Lordship. 100 hectare.
Where Mills Constitution it says 4 hectares?
4 hectare in
Where?
Rule 22D.
How do Mill Concession rules?
Yeah.
Rule 20? Rule?
Rule 22D.
Is it there in the pleadings?
Yes, Your Lordship.
In the pleadings is there. In your pleadings,
In my pleading, it's not I am submission. My submission, Your Lordship.
Oh, you have to put the pleadings, huh? Rule 22D.
Yes, Your Lordship.
G.
DE.
Yes, that's a good point. Yes. 22D.
4 hectare in respect of all deposit other than specified under clause A and B.
Yes.
If central government has prescribed 4 hectare, state government 100 hectare, I think
Yes.
it is not reasonable. This is my humble submission, Lordship.
So there's no reasonable nexus, you mean, between the prescription and the mineral concession rules,
Yes,
right?
yes, Your Lordship.
Is this with regard to minerals or is it coal also?
Coal.
But this one, this chapter 4, under which this rule 22 has been made, is to do with grant of mining leases when a mineral is situated in government land.
Then I was referring to that 95.
No, you
195.
refer to where, even in the concession rules, so now there is where the minerals are not situated in government land. When the government land, they say 4 hectares. This 22D applies in.
And it applied to both government and private person.
No, it
not with
applies
government.
in areas where the minerals vest in the government.
Yeah.
Yes.
But
Now show somewhere
95.
else where when the minerals vest, it's your own private land.
This one 195 of all demersal, sir, I have read.
From the mineral concession rule, there's a provision also. I've read it regarding when the land, when the minerals vest, not vest of the government, what happens?
I was referring to 13.
Come to
2F.
chapter 6. This partly government, partly private.
Yes.
Okay.
Your Lordship.
Then we go around circles. Mr. Archival General.
Yes, Lordship.
Yes.
Lordship, kindly see section 4.5, section 4 of 5 of MMDR Act. Because the thing, what my learned friend is arguing, that state government has no jurisdiction to prescribe any rule.
No. You come round now. He has abandoned that.
Okay.
He has abandoned that notification. Strike notification. Abandoned that.
Yes.
He is now. We were just all throughout other hearings. We were on the other point. I thought that he was assailing the power of the state government to make certain prescriptions. No, he says no.
He is not
questioning. I'm not saying that. I'm only
the rationale of having
that miscellaneous point 15.
Yes,
that's all.
The rationale of having minimum size of 100 hectares.
Yes.
And what my friend has argued, that it has no nexus with the object it seeks to achieve.
Yes.
Therefore, it is finding foul with Article 14. That is what my friend is.
Arguments there now.
This is the argument. For that part also, there are two parts. Whether state government has been conferred with the power to lay down certain criteria or not. Now, second test is those criteria are meeting the requirement of Article 14 or not. First part, whether state government can lay down those criteria for granting mining approval, or the parameters, whether it has power to do it or not. Just see section 5.2 and then I will take to the second part also. Section 4, 1 line, and Section 5 also 2 lines.
Yes.
No person shall undertake any reconnaissance, prospecting, or mining operation in any area.
Yes.
Except under in accordance with the terms and conditions of reconnaissance permit or a prospecting license, or as the case may be of mining lease granted under this act and rules made thereunder. So terms and conditions of the mining lease. Now for mining lease, kindly see Section 5. A state government shall not grant a reconnaissance permit, prospecting license, or mining lease to any person unless such person satisfies such condition as may be prescribed. What my friend is saying, that prescription has to be by way of rule. I do not have quarrel with that proposition, my lord.
That's what 5(1)(b). That's what the
Yes. I have no issue on that. I agree.
You have no issue with that anymore.
Yes. Now, to mining lease shall be granted. No mining lease shall, unless it is satisfied that there is a evidence to show that existence of mineral content in the area for which application has been made according with parameters as may be prescribed by the state central government. There is a mining plan duly approved by central government or the state government in respect of such category of mine as may be by the central government for development of mineral area, and provided that mining lease may be granted upon filing of mining plan in accordance with the system, your lordship, kindly established by state government for preparation, certification and monitoring of such plan and with the approval of central government. So system has to be in place. SOP, my lord, under 5(2)(b) is a system which is in place with the permission of the central government. And why this system has been, and one paragraph of all the Masa, my lord, and then I have to show the SOP, how it is a rational SOP. And Section 6, if your lordship will see what my friend is, the maximum area is prescribed. So therefore, maximum area is prescribed. I can have any size of mine. Your lordship has put pertinently that tomorrow you can go and say that I want to do the mining on 10 by 10 meter area. Because maximum area is prescribed, no minimum area is prescribed. So I am entitled to do mining under 10 by 10 100 meter area or 50 meter area, 25 meter area, because Act only prescribes maximum area that no mining lease can be granted beyond an area of 25 kilometer, 25 under Section 6. So what my friend is saying, that since it is the maximum area prescribed, no minimum area is prescribed, I can do mining on 10 by 10 meter area also.
No, he's saying also if for government minerals, if it's 4 hectares, why can't it say?
No, I will show that. Yes. Now I will show that also. But this is a new argument. But I will show that is also not applicable. Why it is not applicable? You also will see, because this was our submission before Supreme Court, that the state government has very limited role in all these matters. The Supreme Court rejected and said that you have a very important role, which is paragraph 89 of all the Masa, and 90 is the most important. There can be no dispute that provisions that in view of the MMDR Act 1957, legislative competence of a state government under Schedule 7, List 2, Entry 23 stands denuded. However, under the MMDR Act 1957, as well as under Mineral Concession Rules 19, several statutory obligations, jurisdictions have been conferred on the state of Meghalaya, which shall be referred to in the later part of later in this judgment. When a parliamentary enactment, the state government has been given some statutory obligation, there is no lack of jurisdiction in the state to frame policy to give effect to or implement the jurisdiction conferred on the state by the parliamentary enactment. So there is a jurisdiction conferred on the state to frame policy to give effect to parliamentary legislation. And
so that he has no quarrel anymore.
So then in that light, kindly see the...
He's saying only that,
yes,
community in the sense
yes, kindly see the
small holdings, yes, they can't apply money.
Yes, your lordship, why they can't apply mind, your lordship will see the notification. Why this notification and my counter affidavit?
Yes, let's see.
That is the part which I...
The only crux of the whole matter.
Yes, my lord. Kindly see my counter affidavit and my affidavit where I have said this part only I have dealt with that in my counter affidavit, and then your lordship will see the minutes of the meeting which is there at page, give me the page where, see my, so much. So a lordship will see page 9
of your affidavit.
Yes, page 9 of my affidavit.
You are respondent number 1 and 2.
Yes, I am respondent number 1 and 2. That is, affidavit is dated 4th October 2023.
Yes. Page 9.
Page 9 and the minutes which resulted in formation in framing of the policy of which is reflected in a standard operating. Page 10. Lord. Minutes of the stakeholder meeting to discuss the application received from the state government of Meghalaya for scientific and safe mining of coal held on 16th February 2021. A meeting of stakeholders to discuss 16 applications of private landowners regarding prior approval of central government for grant of prospective license cum mining lease for coal received from the state of Meghalaya and scientific, safe and environmentally sustainable coal mining estate was held on 16 February. The meeting was chaired by so-and-so. Now, the GSPS informed the participant that as per judgment of 3rd July 2019, Honorable Supreme Court, my lord, that is the narration of judgment. Paragraph 5 is the comment of a technical member, my lord. Director PND, CMPDIL stated that normally minimum area required for coal mining is 10 square kilometer. Even in scenario under the consideration, the size of mining area should be at least 1 square kilometer, that is 100 hectares. He informed that though the quality of coal in these areas is good, yet large-scale mining is not possible as coal seams are about 1 to 2 meter thick and discontinuous. He also suggested to adopt suitable mining methods which are small scale with small investment and economical to owners. He also stated that prospecting license should be given first for exploration and preparation of geological report based on which mining plans should be prepared. CMPDIL added that GSI has not done exploration in Meghalaya for over a decade and government of Meghalaya should take up the matter with them. He also suggested that the state and the landowner may engage entity like CMPDIL, MECL, GSI, etc. and they can take up prospecting operation under section 4.1 without obtaining any prospecting license or lease. Director Technical CIL suggested that a call on mining lease in these areas may be taken on the basis of prior prospecting. GMCIL undertake to pilot project. Now, Sri Piyush Kumar, CMCIL, Director Technical in the Ministry of Coal, suggested the state government should consult DGMS, Ministry of Labour, for safety aspect. He suggested that prospecting in 1 square kilometer mining area for conducting coal exploration down to minimum depth of 250 meter, 2.50 meter. He added that mining plan can be approved by competent authority by following MOC guideline. Secretary Mining and Geology, Government of Meghalaya, expressed his thanks for the very important meeting. State is rich in coal deposit with 570 million tons proven good quality of coal deposit in Meghalaya. State government has already discussed with these various stakeholders to evolve suitable coal mining methods and has empaneled companies for exploration, prospecting and preparation of geological reports and mining plan. With regard to mining area, he informed that many owners have coal mine areas of about 50 hectares or less. He emphasized that once the geological reports and mining plan are prepared for 100 hectares, proposal to reduce the minimum area to 50 hectares may be examined technically in future. He emphasized that it is important to start coal exploration and requested cooperation of CIL and CMPDIL. In view of the discussion held, the meeting of Joint Secretary PS stated that state government should prepare now an SOP for processing these cases by including following, not necessarily in this order, among the other steps to be decided by state government. Application detail of scrutiny. First application should be made in the previous previous approval central government for prospective license as per Rule 42 of MCR 90. Map of proposed mining area should be plotted on Survey of India map in scale number so and so. A sketch plan of the proposed mining area should be not in the scale of 1 into 4,000. Soft copies, my lord, certify that 6 schedule. Now kindly see A at next page. Sign B. Now H has got application for mining lease of not less than 20 years as per section 7 of MMDR Act, scientific and safe mining. B has got various component. As per discussion, minimum mining area of 1 square kilometer should be considered for prospecting license proposed. State government may consider to do this with consolidation of 2 or more adjoining coal-bearing plots. State government may make effort to sensitize landowners appropriately. Mining plans should be prepared strictly as per guidelines of Ministry of Coal. The state government should consult DGMS on safety issue and stick to the advice and direction of DGMS throughout the mining release. OM of Government of Meghalaya may be amended in accordance with Amendment to Rules and MOC's revised guidelines of 29th May. GS concluded the remarks with the state government would prepare SOP and forward to Ministry of Coal within 7 days with the application and proposal of private community landowners as revised on re-examination of state government. In the light of SOP, it should be given top priority. So in the light of that, my lord, what we did is we prepared the SOP, which is under challenge. And if you also will see page 27 of the writ. Because basic thrust of the entire technical input is, my lord, that any mining of coal less than 100 hectares is scientifically not viable, economically not viable, safety concern not viable.
No, now yes, he himself has condensed the challenge only to the.
And we have also, state government has also requested that please do it for 50 hectares. We have made those kind of requests. We have said that in future, if it is possible, please do it. Now, my friend is saying that this is arbitrary. This has got no rationale. In the light of discussion of the technical members and of the expert committee, my lord, and your lordship, if I do not give them, because this is a prior approval of the central government, and I do not forward the applications which are not in, which are having less than 100 hectares of land, central government will reject the plan, my lord. Because the central government is the key element in the entire discussion and prior permission, because we do not have power to grant prior permission, my lord. It is only central government has the power to grant, and we have to prepare the standard operating procedure so that the prior approval of central government is granted to the applicants. They are not stuck in rigmarole of the bureaucratic setup, my lord. The government of Meghalaya hereby now, my lord, this is the notification, standard operating procedure for processing the application submitted under Mineral Concession Rule 1960 for obtaining previous approval of the central government for grant of prospective license and mining lease for coal in the state of Meghalaya. For previous approval, my lord, I have to follow this SOP which is directed by Ministry of Coal. And then this letter, my lord, requires number of requirements which are part of the Ministry of Coal requirement. And then miscellaneous page 30 where the lordship will glance through the various certificate of status, maps, land documents, everything. And at page 30. And
good. I mean, that is.
So therefore, my lord, what I say, my lord, that our hands are tied. This is a technical matter, my lord. We would like to have mining on smaller piece of land, but fact of the matter, if it is not technically, economically, and it is not meeting the requirements of central government, my lord.
Yes.
We can't help the petitioner.
That's it.
That's it.
Judgment reserved.
Yes. Grateful.
And
we are, all the Masa has left no scope on these aspects. We have to, all the Masa paragraph 91.
No, the only thing was that you
regarding the next part.
Embarking upon the competency of the state government too. But then Mr. Sangma said no. He says fine. The competency
is not in question.
He's not in question only with that part.
Yes.
So then leaves nothing for actually for education. No. Thank you.
Yes. Great. Therefore, your lordship.
Also, which case is this?